Hell yeah. We're live. All right. So I put a 15-second delay on this thing, and I almost wish I didn't because it throws me off. I end up sitting here waiting to see this stuff actually working right, waiting to hear the sound, and I forget that it's on a little bit of delay. Good evening, good evening, good evening. I'm gonna take these off for the moment. Let's see. Hell yeah. We're live. All right. Cool, that sounds good. All right, hopefully some people jump on here because it's no use in me actually doing this thing for actually says just one person watching right now, but that can't be the case. Can't be the case. What's up, Leroy Truth? Tyrants beware. Good to have you. Good to have you. I know I'm kind of shadow banned right now on social media. I know Facebook has got me shadow banned. I can't, it's funny, I can share these videos to bunch of big groups and put it on my page and put it on my profile, and it can reach basically nobody. Facebook's got me completely turned down. So I've got to figure out other ways um to get this stuff out there. Hope everybody's doing all right tonight. If you tuned in earlier today, I did a live stream from the post office because this thing has been um everybody knew it was coming. You don't just lose as much time as I've lost to the just insane amount of corruption that has taken place. And I mean, it's a lot of stuff has come out in the wash, and you're going to see actually with this lawsuit that I'm going to go over, you're actually going to see firsthand yourself um, just the level of I'm just going to say the level of fuckery that these people took. Let me adjust this real quickly so it's a little bit bigger. Okay. Boom. And all right. Cool. So I've actually got a country song created about the stuff that's actually in this complaint. Josephine Syke, it's very good to see you. Um, y'all, please, if you can, share this out. All right. Do me a favor. I'm gonna actually say it like Chili with delete laws says. Okay. Um, take your finger and just tap tap. Just get two quick taps on the screen. Go ahead and throw a like on this video. All right. Share this video out because this is some very important stuff that I'm going to go over, and hopefully you learned something tonight. Because what I want to do is, if I can help any of you with a similar situation, if I can give you any of my advice, I'll be happy to do it. I've always been out there to help people, which is one of the main reasons why I do my activism work. So I want to go over first of all, these are the people that are named in the lawsuit, and I have every intention right now to amend this. I just had to get this in, get this filed um, by the right amount of time. Just so you know, all right, in the state of Texas, for malicious prosecution, there's a 1 year statute of limitations. Now, with what happened with my case, there's actually two different claims of malicious prosecution because I was intentionally overcharged with a felony that they knew should never have been a felony. Okay. Even if I was shit hammered drunk and driving down the road in Texas, they could have only charged me lawfully with a misdemeanor. However, they intentionally overcharged me with a felony and kept me locked up in the Galveston County Jail for almost 11 months. Actually, it was like think I was in there for 8 under the felony before it got dismissed, or 8 or 9 under the felony before it got dismissed. They did that so they could keep $100,000 bond on me and also to help set the stage for what Lafayette County did. They needed me charged with a felony so that they could come in and revoke my probation, my unsupervised probation, and put me in prison for 2 years, which is what they did. All right, so I've got the defendants named as Officer William Osteen, lying ass Osteen. You got Sergeant Jack Doherty. He is the supervisor that was on scene. Jacob McDougal. He is the RN, the nurse at UTMB Hospital that took my blood, that kept sticking me over and over and over at the hospital. There were about six law enforcement officers that forcefully held me face down on the hospital bed. While this was going on, my hands were handcuffed behind my back. That's a violation of policy and procedure right there for the hospital. It was you're either supposed to be unhandcuffed or handcuffed in the front. It got Hobie James. And funny thing about this is one of the Facebook messenger groups that I have, Lafayette County Audit. Um, apparently he was apparently he was on my friends list on one of my old profiles and got added to that Facebook messenger group. And so he um, scopes out my stuff. He's a snake, okay? Um, and I guess he thinks that I can't, see that he's looking at the stuff that I post. But so if he sees this, you earned it, buddy. Candace Beavers, all right, Candy Beavers. Jeff Busby, he is the circuit clerk in Lafayette County, Mississippi. Got the city of Galveston, Texas. UTMB Hospital. John Doe officers 1 to 5, John and Jane Doe's 1 to 6. Okay. I plan to come back and amend this and actually specify who these individuals are. All right. Um, so complaint for damages. All right. We're going to go over this, okay? This civil rights action arises under 42 U.S. Code 1983 and 1985, challenging a coordinated interstate conspiracy to deprive plaintiff Matthew Oliver Reardon of his constitutional rights through false arrest, malicious prosecution, excessive force, deliberate fabrication of evidence, and procurement of a search warrant through perjury. This case involves a systematic violation of the plaintiff's First, Fourth, and 14th Amendment rights by Texas law enforcement officers acting in concert with Mississippi officials to manufacture a felony DWI charge, despite conclusive evidence of plaintiff's sobriety and apparent retaliatory animus based on plaintiff's status as a First Amendment auditor. And you'll see why I use that, because it was something that Osteen specifically said when he came to my window. One of the first things out of his mouth. Two, on August 11, 2023, defendants orchestrated plaintiff's arrest and detention based on fabricated evidence, forced medical procedures, performed pursuant to a warrant obtained through perjury, and a deliberately false enhancement claim that transformed a misdemeanor into a felony charge. This coordinated scheme resulted in plaintiff's wrongful incarceration for approximately 11 months under a $100,000 bond, all while defendants possessed exculpatory evidence proving plaintiff's innocence and the falsity of the enhancement allegations. Number 3, central to this case is Officer Osteen's procurement of a blood draw warrant through deliberate perjury and material representations in his sworn affidavit. As established in Franks v. Delaware, when law enforcement officers make material false statements and warrant affidavits with knowledge of their falsity or reckless disregard for the truth, such warrants provide no constitutional protection, and all evidence obtained thereunder must be suppressed as fruit of the poisonous tree. under Wong Sun versus United States. Number four, the constitutional violations. Hey, Wingspan, welcome to the live stream. Good to have you. The constitutional violations alleged herein were not isolated incidents of poor judgment, but rather the product of a deliberate, coordinated scheme involving multiple law enforcement agencies across state lines, motivated in part by discriminatory animus against plaintiff based on his exercise of First Amendment rights as a government accountability advocate, commonly known as an auditor. Number five, this action seeks redress for violations of plaintiffs' rights under the First, Fourth, and 14th Amendments to the United States Constitution, conspiracy to deprive civil rights under 42 U.S. Code 1985, and related state law claims, including compensatory and punitive damages, declaratory relief, and injunctive relief to prevent future violations. Jurisdiction and venue, that's I'm not even going to read that because um, it just basically specifies that the jurisdiction is right where it's at. All right, let's see. Hell yeah. All right, parties. Uh, plaintiff. Plaintiff Matthew Oliver Reardon is an individual residing in Clearfield, Utah. At all times relevant to this complaint, plaintiff was a visitor to Galveston, Texas, traveling through the jurisdiction when the constitutional violations alleged herein occurred. Plaintiff is an independent investigative journalist that covers stories of public interest and is known to exercise his First Amendment rights as a government accountability advocate. Individual defendants. All right. Let's see. Looks like I zoomed in a little bit too much right there. Defendant Officer William Osteen is a sworn law enforcement officer employed by the Galveston Police Department. At all times relevant herein, Osteen was acting under color of state law within the scope of his employment. Osteen is sued in his individual capacity for money damages. Osteen was certified as a certified breath test operator by the state of Texas, yet deliberately misrepresented to plaintiff that no breathalyzer equipment was available. Osteen was the primary investigating officer who initiated and pursued the false charges against plaintiff, made material misrepresentations and perjurious statements in his sworn affidavit, deliberately omitted exculpatory evidence from his documentation, coordinated with out-of-state officials to fabricate enhancement allegations, and committed perjury in subsequent judicial proceedings. Osteen repeatedly disabled his body-worn camera audio during critical portions of the investigation, demonstrating consciousness of wrongdoing. Um, does this brief mention showing you the warrant? I was never showed the warrant. That's actually in this. It's not a brief; it's a lawsuit, and it's actually in here. Um, so yeah, this is going to be fun. That we got this guy in here, y'all. Uh, watch that one close. All right. Defendant Sergeant Jack Doherty is a supervisory law enforcement officer employed by the Galveston Police Department. At all times relevant herein, Doherty was acting under color of state law within the scope of his employment. Doherty is sued in his individual capacity for money damages. Doherty was present during the constitutional violations, had supervisory authority over the officers involved, and failed to intervene to prevent or stop the violations despite clear opportunity and duty to do so. 12. Defendant Jacob McDougall is a registered nurse employed by UTMB Health, who at all times relevant herein was acting under color of state law in conjunction with law enforcement. McDougall was sued in his individual capacity for money damages. McDougall performed the forced blood draw on plaintiff while plaintiff was restrained by multiple officers without plaintiff's consent, despite plaintiff's explicit objections and stated fear of needles, pursuant to a warrant that was procured through perjury and material representations. 13. Defendant Hobie James is a sworn law enforcement officer employed as a deputy by the Lafayette County Sheriff's Department in Mississippi. At all times relevant herein, James was acting under color of state law. James is sued in his individual capacity for money damages. On the night of plaintiff's arrest, James initiated contact with the Galveston Police Department and provided false information regarding plaintiff's criminal history, specifically falsely claiming that plaintiff had sustained a final conviction for DUI in Mississippi, when no such final conviction existed. 14. Defendant Candace Beavers is a sworn law enforcement officer employed as a deputy by the Lafayette County Sheriff's Department in Mississippi. At all times relevant herein, Beavers was acting under color of state law. Beavers is sued in her individual capacity for money damages. Beavers previously provided false testimony in Mississippi proceedings involving the plaintiff and participated in the coordinated scheme to provide false information to Texas authorities to support the fabricated felony enhancement. 15. Defendant Jeff Busby is the circuit clerk of Lafayette County, Mississippi. Let me see if I can put this on a split screen without it messing up the. Let's see. Actually, that works. If it doesn't change the perspective right there. Let's see. At all times relevant herein, Busby was acting under color of state law within the scope of his official duties. Busby is sued in his individual capacity for money damages. Busby provided official correspondence on county letterhead. Okay, so that actually did do what I did not want it to do. All right. Let's see. Let me pause right there for 1 second. Okay. In the meantime, I'm just trying to make sure the screen portion is correct. I've got this right here. Hey, tell me what you think about this. It's called Warrant for a Lie.
Stepped out with a smirk and a plan, said this one's an otter, not your average man. He ignored the law, he ignored my breath, wrote up a script that midnight wheels rolling slow down a coastal Texas line. No drinks, no buzz, just a clear head and peace of mind. Then a bad stepped out with a smirk and a plan, said this one's an otter, not your average man. He ignored the law, he ignored my breath, wrote up a script that would fake me to death. Eyes weren't glassy, words weren't slurred, but he made up a storm from things never heard. They signed a warrant for a lie, drew my blood and watched me cry. Said I smelled like booze, hell I hadn't drank in years, but the truth don't matter when the system's run by fear. They jailed me up and threw away the key, while my kids asked daddy when you coming free. It was murder of the truth and a badge and tie. They locked me down on a warrant for a lie. UTMB hands with needles like knives, didn't show no paper, didn't care about rights. Already stood there, knew it wasn't just. Go back the blue line, let me bleed in the dust. Meanwhile back east they were ringing the phone, Mississippi snakes with a thirst for my bones. James and Beavers, Busby too, sent lies through the wire like it was all true. They signed a warrant for a lie, drew my blood and watched me cry. Said I smelled like booze, hell I hadn't drank in years, but the truth don't matter when the system's run by fear. They jailed me up and threw away the key, while my name got dragged through Galveston Sea. They made a felony out of thin blue sky just to silence my voice with a warrant for a lie. And the blood watch me cry, but I'm singing louder now. My story don't bend, and I'll fight these devils straight through to the end. Cause the truth stood up and the charges died, and I've still got my name, my grit, my pride. No man should ever be crucified by the stroke of a pen on a warrant for a lie.
All right, I'm back. I'm back. Okay. So let me make this just a little bit bigger. That should work right there. Man, I like that song. I love it. All right, let's get back to it. Um, welcome, the Vigilance Committee. I didn't see what happened right there with Frauditor Mania, but I'm sure he did something. So let's see. Where's my document? Okay. All right. So the municipal and institutional defendants. Defendant City of Galveston is a municipal corporation organized and existing under the laws of the state of Texas. Um, the City of Galveston employs defendants Osteen and Doherty and is responsible for their training, supervision, and discipline. The City of Galveston maintained policies, customs, and practices that were the moving force behind the constitutional violations alleged herein. The City of Galveston is sued for money damages and to the extent permitted by law and for prospective injunctive and declaratory relief. 17. Defendant UTMB Health is a component of the University of Texas system, and it operates as a state actor providing medical services. UTMB Health employed defendant McDougal and other medical personnel who participated in the constitutional violations alleged herein. Oh, Mania was supporting me? Well, I don't. Why does he have his name as Frauded or Mania? It's very confusing. I didn't time him out, but it's very misleading. So um Vigilance Committee. All right. UTMB Health, the hospital in Galveston, is sued for money damages to the extent permitted by law and for prospective injunctive and declaratory relief. The unknown defendants, defendants John Doe officers 1 to 5 are sworn law enforcement officers employed by the Galveston Police Department whose identities are currently unknown to plaintiff. These officers participated in the physical restraint of plaintiff during the forced blood draw and other constitutional violations. They are sued in their individual capacities for money damages. 19. Defendants John and Jane Does, 1 to 6, are employees or agents of UTMB Health whose identities are currently unknown to plaintiff. These individuals participated in or facilitated the forced medical procedures performed on plaintiff pursuant to a warrant procured through fraud. They are sued in their individual capacities for money damages. Here's the background. Here's the facts. All right. Number 20. Hey, Gloria, how you doing? Welcome, welcome, welcome. Welcome to the live stream. All right, y'all share this out, please. If you haven't liked the stream yet, you can either, drag down and hit that like button or, and I didn't know this until I saw Delete Laws, Chili, talk about this, but you can double tap the screen and that is apparently supposed to um, give the thumbs up. So helps out the algorithm. Doing this to because I think it should be done. Honestly, I mean it's about to be public record anyways, and if I can help some people along the way, then great. All right. Here's the background and context. This case arises from a coordinated interstate conspiracy. Hey, what's up, East Corbin? Good to see you. An interstate conspiracy to deprive the plaintiff of his constitutional rights through the fabrication of evidence, procurement of search warrants through perjury, malicious prosecution, and excessive force. The conspiracy involved law enforcement officers and officials in both Texas and Mississippi who communicated directly to share false information and coordinate prosecutorial actions designed to harm plaintiff in retaliation for his previous legal challenges to Mississippi authorities and his exercise of First Amendment rights as a government accountability advocate. 21. Plaintiff's constitutional rights were violated not through isolated acts of misconduct, but through a deliberate scheme orchestrated by multiple defendants across state lines. The evidence establishes that Mississippi officials, including defendants James, Beavers, and Busby, initiated contact with Texas authorities on the night of plaintiff's arrest and continued to provide false information throughout the prosecution to ensure plaintiff's continued incarceration and prosecution. Like I said, I've got to amend this, and actually, I meant to. Um, James and Beavers initiated contact with the Texas authorities, and I had put accidentally I'd put all Lafayette County defendants right there. So that'll be Busby will be out of that little part right there in the amended complaint. Um, 22 at approximately 2 a.m. on August 11, 2023, plaintiff was driving through Galveston, Texas when he was pulled over by Officer Larry Murph for allegedly reckless driving. Joco, Kansas City, or Kansas Cop Watch. Very good to have you on here. Uh, when he was pulled over by Officer Larry Murph for allegedly reckless driving. Plaintiff had not consumed any alcoholic beverages and had maintained sobriety for over 3 years prior to this incident. Officer Murph conducted the initial stop but quickly transferred the investigation to Defendant Osteen, who assumed control of the encounter and made all subsequent decisions regarding plaintiff's detention and arrest. 24. Upon approaching plaintiff's vehicle, one of the first questions Defendant Osteen asked was, "You an auditor, man?" Osteen then informed another officer, "Hey, I'm doing this one. This is an auditor." And he really said that. I've seen that. I've seen the body cam. He legitimately right after that, after he left my window, he went to the officer and said, "Hey, look, I've got this. It's an auditor." These statements captured on body camera footage demonstrate that Osteen's subsequent conduct was motivated not by evidence of criminal activity, but by discriminatory animus against plaintiff based on his exercise of First Amendment rights as a government accountability advocate. Hey, I appreciated these, Carbon. 25. Throughout the encounter, plaintiff was cooperative and compliant with lawful orders. When questioned about alcohol consumption, plaintiff truthfully informed officers that he had not consumed alcohol and had been sober for over 3 years. Plaintiff explicitly and repeatedly requested to take a breathalyzer test to demonstrate his sobriety. 26. Defendant Osteen falsely claimed that the Galveston Police Department did not have access to a portable breathalyzer device and refused to allow plaintiff to take a breath test. This representation was false, as breathalyzer equipment was available and routinely used by the Department for DWI investigations, and Osteen was certified as a certified breath test operator by the state of Texas. 27. Instead of allowing the breath test that plaintiff requested, Defendant Osteen insisted the plaintiff submit to field sobriety test. Plaintiff declined to perform field sobriety tests, citing their subjective nature and his constitutional right to refuse such test. Plaintiff's refusal was lawful and cannot constitute probable cause for arrest. 28. Despite plaintiff's continued cooperation, his explicit request for a breath test, his truthful statements about sobriety, and the absence of any objective indicators of intoxication, Defendant Osteen placed plaintiff under arrest for driving while intoxicated. The fraudulent warrant procurement and perjurious affidavit. 29. Following the arrest at approximately 2:49 a.m. on August 11th, 2023, defendant Osteen applied for and obtained a search warrant for plaintiff's blood. However, as detailed in a subsequent motion for Frank's hearing, filed in the underlying criminal case, Osteen's warrant affidavit contained numerous material false statements made with knowledge of their falsity or reckless disregard for the truth. 30. Specifically, Osteen's affidavit falsely claimed he observed the following signs of alcohol intoxication. A. An odor of an unknown alcoholic beverage emitting from the vehicle. And not just an odor. Let me put this out there. But he noted on the application for the judge to sign off that it was a moderate smell. Moderate is the second to the most. You know, there I can't remember what the highest level is, but moderate is a step down below. There's absolutely no way that there could be a moderate odor of alcohol and for alcohol not to be present. He's full of shit. Okay. Um, uh, B. Matthew to have watery, glossy eyes. C. Walking heavy footed. D. Speech slurred and thick tongued. And eventually, okay, the videos will come out, and it'll be after this is all. You know, it won't be while this is pending. It'll be after this is all resolved. Okay, but you'll be able to see that none of this stuff is true. None of it. E. Eyes watery and dilated. And F. Odor of alcoholic beverage on breath moderate. Okay. 31. These statements were materially false and made with reckless disregard for the truth, as evidenced by the subsequent toxicology report showing zero alcohol content in plaintiff's blood. B. Osteen's own body camera footage contradicting his claims. C. His own statements on camera clarifying that he smelled no alcohol on plaintiff's breath, only from the vehicle. And D. His later contradictory testimony under oath in judicial proceedings. And this would be the revocation proceeding in Mississippi where he testified over Zoom. It was more important for him and them to put me in prison right then than to make sure that they didn't just completely screw it up and give the farm away on their conspiracy. Okay. Um, 32. Most damaging to Osteen's credibility. He later testified under oath in plaintiff's probation revocation hearing with completely contradictory observations, claiming plaintiff had pinpoint pupils instead of dilated pupils, was talking extremely fast instead of having slurred, thick-tongued speech, and was extremely jittery instead of heavy-footed. These fundamentally opposite observations cannot both be true and demonstrate either perjury in the warrant affidavit or perjury in the subsequent testimony. One or the other. Additionally, Osteen deliberately omitted from his warrant affidavit the material fact that plaintiff had explicitly requested and consented to a breathalyzer test. Instead, falsely characterizing plaintiff's lawful refusal to perform subjective field sobriety test as a refusal to provide a sample in violation of the Texas implied consent law. They actually sent me something to my address saying that my license was suspended because I refused a breath, or it's like, I never refused a breath test. I kept asking for it. They refused me the test. 34. Under Franks v. Delaware, when a defendant makes a substantial preliminary showing that false statements were knowingly and intentionally or with a reckless disregard for the truth included in a warrant affidavit, and if the allegedly false statements are necessary to the finding of probable cause. The Fourth Amendment requires that the warrant be voided and all evidence obtained thereunder be suppressed as fruit of the poisonous tree. Okay. Um, let's see. Just looking at the comments real quickly. All right. Forced blood draw pursuant to fraudulent warrant. 35. Following procurement of the fraudulent warrant, defendants transported plaintiff to UTMB hospital for the purpose of obtaining a blood sample. Although a warrant existed, plaintiff was never informed of its existence, despite his repeated request for legal justification for the procedure. Upon arrival at UTMB Hospital, plaintiff was escorted to a treatment room where he was surrounded by approximately 6 law enforcement officers, including defendants Osteen and Doherty, along with John Doe officers 1 to 5. 37. Defendant Sergeant Doherty was specifically summoned to the scene by defendant Osteen when plaintiff requested a supervisor. Doherty arrived at UTMB Hospital with full knowledge of the circumstances and observed the entire forced medical procedure that followed. 38. Plaintiff clearly and repeatedly stated his objection to the blood draw procedure. Plaintiff explicitly informed all present that he had a severe fear of needles and did not consent to the procedure. Plaintiff continued to request that he be allowed to take a breath test instead of the invasive blood draw. 39. Despite plaintiff's clear objections and explicit refusal to consent, and despite his repeated request to see the warrant or other legal authorization, defendants proceeded with the blood draw by force. Plaintiff was handcuffed behind his back and physically restrained by multiple officers while defendant McDougal attempted to draw blood. 40. The initial blood draw attempt was unsuccessful, causing additional pain and trauma to the plaintiff. Defendant McDougal made multiple attempts to obtain blood, requiring repeated needle insertions while plaintiff remained restrained and objecting. 41. Throughout the forced procedure, plaintiff invoked his right to counsel and continued to object to the blood draw while requesting to see the warrant that authorized it. These objections and requests were ignored by all defendants present. 42. Even where a warrant exists, the execution of that warrant must be reasonable under the Fourth Amendment. The defendant's failure to inform plaintiff of the warrant's existence, their use of excessive force to overcome his constitutional objections, and their deliberate infliction of additional pain through multiple needle insertions constituted an unreasonable execution of the warrant. See United States v. Ramirez. 43. Moreover, because the warrant was procured through materially false statements made with reckless disregard for the truth, and it provided no constitutional justification for the search under Franks v. Delaware, and the search violated plaintiff's Fourth Amendment rights. 44. Defendant Doherty, as his supervising officer present, had the authority and duty to intervene and prevent the constitutional violations occurring in his presence. Despite having clear opportunity to stop the unlawful conduct, Doherty failed to take any action and instead allowed the violations to proceed. E. The exculpatory evidence and continuing prosecution. On September 6, 2023, the Texas Department of Public Safety issued an official toxicology report confirming that no alcohol was detected in plaintiff's blood sample. This report conclusively established plaintiff's sobriety at the time of arrest and demonstrated that no probable cause existed for the DWI charge. 46. The zero blood alcohol finding also proved definitively that Officer Osteen's warrant affidavit contained materially false statements, as it would be physically impossible for plaintiff to emit a moderate odor of alcohol from his breath or exhibit alcohol-related impairment symptoms while having zero alcohol in his system. Despite receiving this exculpatory evidence, proving both plaintiff's innocence and the falsity of the warrant affidavit, defendants continued the prosecution and took affirmative steps to enhance the charges against plaintiff from a misdemeanor to a felony. The enhancement from misdemeanor to felony required proof that plaintiff had sustained 2 or more DWI convictions. This enhancement was critical because it transformed what would have been a minor misdemeanor with no alcohol detected into a serious felony carrying substantial prison time and bond requirements. All right, F, the interstate conspiracy and fabrication of enhancement evidence. At exactly 2:41 a.m. on August 11, 2023, while plaintiff was being transported to UTMB Hospital for the forced blood draw, defendant Hobie James, a deputy with the Lafayette County Sheriff's Department in Mississippi, placed a direct phone call to the Galveston Police Department dispatch. This call is documented in official GPD call logs and represents the initiation of interstate conspiracy alleged herein. Hey, Lisa Lynn, welcome to the live stream. Thank you for joining. 50, the timing of James' call occurring during the active arrest and forced blood draw procedure demonstrates premeditation and coordination. James specifically requested to speak with the officer that arrested him, indicating prior knowledge of plaintiff's arrest and the specific officers involved. 51. During subsequent calls documented in GPD records, defendant James provided materially false information to Galveston officers regarding plaintiff's criminal history. Specifically, James falsely represented that plaintiff had sustained a final conviction for DUI in Mississippi, when in fact no such final conviction existed due to pending appellate proceedings that James knew were active. 52. At 4:04 a.m., defendant Candace Beavers, who had previously provided false testimony under oath in Mississippi proceedings against plaintiff in 2022, called Galveston PD to reinforce the false criminal history information. I'm suing him, and I'm suing a lot more. Beavers' participation demonstrated the coordinated nature of the conspiracy and her personal animus against or toward the plaintiff. 53. The false information provided by defendants James and Beavers was material to the Texas prosecution because it formed the sole basis for the felony enhancement that transformed a misdemeanor charge with zero blood alcohol content into a third-degree felony carrying a $100,000 bond and potential imprisonment of 2 to 10 years. 54. In approximately November 2023, after receiving inquiry from Galveston County prosecutors about the status of plaintiff's Mississippi case, defendant Jeff Busby, in his official capacity as the circuit court clerk, Lafayette County, provided a letter on official county letterhead. Now, these people should go to prison. They shouldn't just be fired. They need to go to prison, is what they need to do. They need to go to prison. This is crimes committed. It's an abuse of power and crimes committed. To Galveston County District Attorney's Office. This letter falsely stated that no appeal was pending in plaintiff's Mississippi DUI case. Defendant Busby's representation was materially false, as an appeal was in fact pending at the time of his correspondence, and this information was readily available in the official court records under his control. The false representation was designed to make it appear that plaintiff's Mississippi case had reached final disposition, thereby providing documentary support for the felony enhancement in Texas. 56. The coordination between Mississippi and Texas officials was not coincidental or inadvertent. The evidence establishes a clear temporal sequence. 1. Plaintiff's arrest at 2:11 a.m. 2. Mississippi officials' immediate contact with Texas authorities at 2:41 a.m. 3. Provision of false criminal history information designed to support felony charges. 4. Continued coordination to suppress exculpatory evidence. And 5. Provision of false official documentation to prosecutors. This sequence demonstrates that these defendants acted in concert with the specific intent to deprive plaintiff of his constitutional rights and to ensure his continued prosecution and incarceration. These people, it's beyond they need to be fired. Now these people need to go to prison. This is beyond criminal. You do something like this to somebody, especially if you're a public official, your ass belongs in prison. In fact, honestly, if you ask me, it's deserving of a charge of treason. Okay, and honestly, I mean, as I've said in the writing with the outlaw, the first, where the story begins, when it's political, when it's public employees, public officials like this, it should be a charge of treason, and it should be a punishment of capital punishment. 100%. 100%. Because I mean it's you can't change those people. 57. Based on the false information provided by the Mississippi defendants and despite possessing exculpatory evidence proving plaintiff's sobriety, the Galveston County District Attorney's Office sought and obtained a felony indictment against the plaintiff on December 7th, 2023. 58. The indictment charged plaintiff with felony DWI third or more, falsely alleging that plaintiff had sustained 2 or more prior DWI convictions. This allegation was known to be false by Texas authorities who had received information from Mississippi officials that contradicted the enhancement claim. 59. The false felony indictment resulted in plaintiff being held under a $100,000 bond, which was substantially higher than it would have been imposed for a misdemeanor charge, or if accurate information about plaintiff's criminal history had been provided. 60. Plaintiff remained incarcerated from August 11, 2023 to approximately July 2024, a period of nearly 11 months due to the false charges and enhancement allegations fabricated by the defendants. And of course, at that time, I was including like whenever I got extradited over to Mississippi, it was about that time that I went off to prison, where I was robbed of a trial because 2 weeks prior to trial on the misdemeanor, I was extradited to Mississippi. This was part of their plan, and they had a lot lower of a burden of proof to meet, and they had Osteen's lies, and they sent me to prison before this false charge was even adjudicated. H. The Franks motion and prosecutorial capitulation. 61. In February 2025, plaintiff's criminal defense attorney filed a comprehensive motion for a Franks hearing, documenting in detail the material false statements in Officer Osteen's warrant affidavit and presenting evidence of Osteen's perjurious conduct in subsequent proceedings. 62. The Franks motion presented compelling evidence that Osteen had committed perjury, both in his warrant affidavit and in his subsequent testimony, including his false claims under oath that the toxicology report had found alcohol in plaintiff's system when it had not. 63. Faced with overwhelming evidence of Officer Osteen's perjury and the invalidity of the search warrant, the Galveston County District Attorney's Office dismissed all charges against the plaintiff just days before the scheduled Franks hearing. explicitly stating that the state cannot prove beyond a reasonable doubt the charges against the plaintiff. They didn't want Osteen testifying. That's what that was all about, 100%. I can tell you right now, guaranteed 100%. They held on to their bad hand as long as they possibly could. But when it came down to it, when we had the hearing set up to put Osteen on the stand about his intentional lies, okay, that was going to be devastating. They decided they had to throw it out at that point, so there wasn't any more of a record of it. They let go of their bad hand. 63, faced with overwhelming evidence of Officer Osteen's perjury and the invalidity of the search. 64, the dismissal represents a favorable termination of the prosecution for purposes of plaintiff's malicious prosecution claims and confirms the absence of probable cause for all charges, both misdemeanor and felony. 65. The timing of the dismissal immediately before a hearing where Officer Osteen would be required to defend his contradictory statements under oath demonstrates the prosecution's recognition that the charges were unsupportable and that Osteen's conduct was indefensible. I. Ongoing retaliatory conduct and pattern of constitutional violations. All right. 66. The prosecution and continued charging of the plaintiff even after the dismissal of the felony charges represents ongoing retaliatory conduct designed to trigger revocation of plaintiff's probation in Mississippi and to punish him for his exercise of First Amendment rights. 67. The interstate nature of the conspiracy and the coordination between defendants in different jurisdictions establishes a pattern of conduct designed to circumvent plaintiff's constitutional protections and deny him due process of law. 68. The evidence demonstrates that plaintiff's targeting and prosecution were motivated not by evidence of criminal conduct, but by discriminatory animus based on his status as a First Amendment auditor and retaliatory animus for his previous legal challenges to Mississippi authorities. So let me pause right there. And what I'm going to do real quickly, okay? See, it gets up to like 10. I'm not sure. I can just about guarantee you, and this is one of the reasons why I did this, okay? I can about guarantee you that the nosy folks in Lafayette County, and I might even have one or two on from Galveston on here. So, that was basically, I did that I wanted to draw them in long enough to kind of, hear some of, I'm sure they've heard the caught red-handed by now, but in case they haven't, we're going to go ahead and we're going to listen to that right now.
Caught red-handed, their lies laid bare. These public officials thought nobody would care. A conspiracy deep, but the truth's coming through. The system's cracking, now they'll pay their due. Lies and corruption, they thought they'd control, but justice is burning, exposing their soul. They built this on deceit, but their cover is blown. Now the guilty must answer for the seeds they've sown. Down in Galveston, it started that night. Osteen and Doretti turned wrong into right. Said I was drunk, claimed the smell in the air, but no alcohol touched me, their proof wasn't there. They locked me up 11 months in a cell. Fabricated charges of personal hell. They twisted the law, made me a pawn, but their conspiracies unravel and it won't last long. A growing plot, their power abused, but I'm breaking the chains, their lies are diffused. The truth's on my side and it's ready to speak, exposing their game, bringing justice to the weak. Caught red-handed, their lies laid bare. These public officials thought nobody would care. A conspiracy deep, but the truth's coming through. The system's cracking, now they'll pay their due. Lies and corruption, they thought they control, but justice is burning, exposing their soul. They built this on deceit, but the cover is blown. Now the guilty must must answer for the seeds they've sown. Extradited from Galveston back to Lafayette 2 weeks before trial, the lies were set. Then Ben Creekmore played his false hand, fictitious evidence in his corrupt plan. Judge Tolleson fell for the charade they showed. 2 years in prison, down a dark road. Austin hit the stand, swore oath after oath, but his lies cracked under the weight of my growth. July 18th, they thought they'd won, but justice don't sleep, the truth has begun. Their house of cards is shaking, ready to fall. I'm standing tall, calling out them all. Caught red-handed, their lies laid bare. These public officials thought nobody would care. A conspiracy deep, but the truth's coming through. The system's cracking, now they'll pay their due. Lies and corruption, they thought they control. Sentence vacated, exposing their soul. They built it on deceit, but the cover is blown. Now the guilty must answer for the seeds they've sown. Candy Beavers, Hobie James played the dirty part. Conspired with Galveston to tear me apart. Jeff Busby sent false statements to the district attorney, and when the heat came down, it was so concerning. A snake in the grass hiding behind his crew, but the truth reveals everything they do. Their lies run deep, but justice runs deeper. Each betrayal exposed, the climb's getting steeper. They thought they'd silence me, bury my voice, but now it's my time and I've made my choice to shine a light, make sure these criminals pay. Justice is coming and it's here to stay. I lost it all, but I've still got the fight. Damn right, the truth's a weapon cutting through the night. The sentence declared unlawful, the order vacated. I'm vindicated, liberated, and of course I'm elated. Caught red-handed, their lies laid bare. These public officials thought nobody would care. A conspiracy deep, but the truth's coming through. The system's cracking, now they'll pay their due. Lies and corruption, they thought they control. Sentence vacated, exposing their soul. They built it on deceit, but the cover is blown. Now the guilty must answer for the seeds they've sown. Yeah, Paul Reagan. Damn right, the truth's a weapon cutting through the night. The sentence declared unlawful, the order vacated.
Right. So, you know me, I like my music, and here's the thing, okay? Is at the end of the day, um, I want these people to know, all right, if there's one thing that one message I wanted to give, it's that you mess with the wrong fucking person, okay? Obviously, um, you could stop making it worse because it's just going to keep inflaming the situation that much more. I mean, by now, you bad actors that are on here, if you're watching right now, um, I just want you to know that I'm going to make sure that your name lives in infamy for the rest of your life. In fact, I'm actually working on a full and complete album that's all about you bad actors. Literally, it's going to. I mean, you earned it. You you earned it. What can you do? Are you gonna sue me over First Amendment stuff when you did this stuff? So you earned it, all right? And push my fucking buttons again. All right. So let's see. Now we've got the claims for relief right here. All right. Count one. Let's see. Count one, malicious prosecution. Okay. And as I said, I'm going to be amending the complaint, going to be adding defendants because I won't be taking defendants away. I'll be adding defendants, and I'm going to be adding counts because there's a second malicious prosecution count on here because I was ultimately charged twice and I have two different dismissals. And there's a malicious prosecution for the first one, for when the felony was dismissed, And then the dumbasses recharged me with a misdemeanor. And then what they should have done is they should have just dismissed it right then. They would have saved themselves a malicious prosecution claim. They would have just had one instead of two. But now, because they recharged me and all this other stuff happened, and then they dismissed, they're getting sued. They're going to get sued for two different malicious prosecution claims, and they did it. Okay. So against defendants Osteen, Doherty, James, Beavers, and Busby. By the way, I'm going to also add the Galveston, uh, and I realized that there's a couple of things in particular that I realized that I left out of here. For one, they stole my car and sold my car at public auction. I didn't even touch on that. I was touching on, the bigger picture. But they seized my car and they sold it at public auction. Um, and that was pretty personal, especially when they used the keys. They stole the keys and used the keys to bait me up to the police department to rearrest me. The other one is uh, the, Osteen basically presented everything to the district attorney that night whenever they intentionally chose to charge me with a felony. Um, there's been collusion with Lafayette County. I have every intention of suing the Galveston County District Attorney's Office as well. So I, when I amend the complaint, I guarantee the Galveston County District Attorney's Office is going to be on there. Might even have the Lafayette County District Attorney's Office on there. And, there's going to be a lot of stuff that's going to come out in the wash on discovery. I can't wait. Can't wait for discovery, and I can't wait for depositions. All right. Um, yeah. You you cops out there watching, have you ever seen a cop, a dirty cop have his deposition put on the internet and it goes viral? Just think about that situation for a second, because that situation's actually it's a reality coming. 69. Plaintiff incorporates by reference all preceding allegations as if fully set forth herein. Oh, and by the way, for all the bad actors out on there, because this has happened multiple times before in the past, if you retaliate on me for this, it's already filed. So help me God. You retaliate on me for what you deserve, what's, for taking legal action, you'll be opening up, a whole set of problems that telling you don't want. 70, defendant Osteen. Uh, yeah, I know. Defendants Osteen, Doherty. What's up, Bobby Kennedy? James, Beavers, and Busby, acting under color of state law, initiated and continued criminal proceedings against the plaintiff without probable cause and through the procurement of search warrants based on material false statements. Yeah, hey, it doesn't get more real than this. It's all backed by evidence. It's you know the you can look at the criminal case online that's dismissed now, and look at the motion for a Franks hearing. In fact, I've got it on my website, wtpnews.org. I say it every night. I'm going to update it with new articles, and then I pass out, go to sleep, and I forget to update it with new articles. I'm going to do it tonight. Defendant Osteen procured the blood draw warrant through material misrepresentations and perjurious statements in a sworn affidavit in violation of Franks v. Delaware. These false statements included but were not limited to fabricated observations of alcohol-related impairment that were contradicted by the subsequent zero blood alcohol toxicology report. What's up with you, Jordan? Welcome, welcome, welcome. 72. These defendants knew or should have known that no probable cause existed for the DWI charges, particularly the felony enhancement, as evidenced by the toxicology report showing zero alcohol in plaintiff's system. B. The absence of any final Mississippi conviction to support the enhancement. C. The pending appeal that precluded any final conviction. D. Their own communications acknowledging the lack of evidence. Oh man, I wish I could play that for you. Can't. But yes, they actually acknowledge over the radio, on phone calls, that they've run my history. There is no history of a DUI in Mississippi. So even with running an NCIC report and seeing nothing in the record about it, they still chose to intentionally overcharge me. The material contradictions in Osteen's sworn statements. 73. The defendants actively participated in the initiation and continuation of the prosecution by providing false statements or false information to prosecutors, making perjurious statements in warrant affidavits, omitting material exculpatory evidence from reports, coordinating across state lines to maintain false charges, and providing false official correspondence to support the prosecution. 74. The criminal proceedings terminated in plaintiff's favor when the state dismissed the charges just days before the Franks hearing, explicitly acknowledging its inability to prove the charges beyond a reasonable doubt. As a result, 75. As a direct and proximate result of defendant's conduct, plaintiffs suffered severe injuries, including deprivation of liberty for approximately 11 months. And that, I'll say, is just in the Galveston County Jail. Okay? Because at that point, they then dumped me off to extradition to get extradited to Lafayette County, Mississippi, and held a revocation hearing where they had Osteen testify over Zoom and tell lies, complete lies. Got the transcript. Actually, I don't know if I've published the transcript from that yet. If I haven't, I'll publish it tonight. For showing his lies at the revocation hearing. 75. As a direct and proximate result of defendant's conduct, plaintiffs suffered severe injuries, including, yeah, all right, damage to reputation and standing in the community, severe emotional distress and mental anguish, financial losses, including legal fees and lost income, and ongoing trauma and anxiety. You're actually not far off what I was told that I should go for, that my case was worth in compensatory damages, Bobby. That's not punitive. Punitive goes way up there. Let's see, 76. Defendant's conduct was objectively unreasonable and violated clearly established constitutional rights, including the right to be free from prosecution based on fabricated evidence and fraudulently obtained warrants, including any defense of qualified immunity. All right. Count 2. Unreasonable search and excessive force under 42 U.S. Code 1983 under the Fourth Amendment against defendants Osteen, Doherty, McDougal, and John Doe officers 1 to 5. 77. Plaintiff incorporates by reference all preceding allegations as if fully set forth herein. 78. Defendant subjected plaintiff to an unreasonable search and excessive force in violation of the Fourth Amendment by conducting a blood draw pursuant to a warrant procured through fraud and by using unreasonable force in the execution of the warrant. 79. Under Franks v. Delaware, a search warrant obtained through material false statements made with knowledge of their falsity or reckless disregard for the truth. What's up, Popeye's transparency? Provides no constitutional protection, and the search conducted pursuant to such a warrant violates the Fourth Amendment. 80. Even if the warrant had been validly obtained, defendant's execution of the warrant was unreasonable under the circumstances. The Fourth Amendment requires that searches be conducted in a reasonable manner. See United States v. Ramirez. 81. The defendant's conduct was unreasonable because they failed to inform plaintiff of the warrant's existence despite his repeated request for legal justification. Used excessive force to restrain plaintiff during the procedure, ignored his medical concerns about needles. D. Performed multiple unsuccessful needle insertions causing unnecessary pain. And E. Refused to allow him to take the breath test he had requested and consented to. 82. The physical force used to restrain plaintiff during the blood draw was objectively unreasonable under the circumstances, as plaintiff posed no threat to officer safety or flight risk, and the force was used solely to overcome his constitutional objection to an unlawfully obtained search warrant. 83. Defendants McDougal and John Doe officers 1 to 5 actively participated in the constitutional violation by physically restraining plaintiff and performing the blood draw despite the fraudulent nature of the warrant authorizing it. Hey, you know what's funny? All right? You don't see any trolls coming on here calling me a dumbass, okay? Calling me uneducated. Where are they at? You know? I don't really see any trolls in the reading of this. So, I think that speaks for itself. 84. Defendant Doherty is a supervisory officer present during the violations, had the authority and duty to intervene, but failed to take any action to prevent the constitutional violations. What's up, Wingspan? 85. The defendant's conduct was objectively unreasonable and violated clearly established constitutional rights, of which a reasonable officer would have known. Count 3. First Amendment retaliation. 42 U.S. Code 1983 against defendants Osteen and Doherty. 86. Plaintiff incorporates by reference all preceding allegations as if fully set forth herein. 87. Defendants Osteen and Doherty violated plaintiff's First Amendment rights by retaliating against him for his exercise of constitutionally protected speech and expressive conduct as a government accountability advocate. 88. Plaintiff engaged in constitutionally protected activity by exercising his First Amendment rights to observe, record, and critique government conduct in his capacity as a First Amendment auditor. Okay. 89. Defendant's immediate identification of plaintiff as a auditor and Osteen's statement, "I'm doing this one, this is an auditor," demonstrate that his subsequent arrest and prosecution were motivated by discriminatory animus against the plaintiff based on his exercise of First Amendment rights. 90. Defendants took adverse action against plaintiff, including arrest, prosecution, and denial of his request for a breath test that was motivated by his protected First Amendment activity. 91. The adverse actions taken by defendants would chill a person of ordinary firmness from continuing to engage in protected First Amendment activity. See Hartman v. Moore. 92. Yeah, they do. Defendant's retaliatory conduct violated clearly established First Amendment rights and is not protected by qualified immunity. The hell? Huh. Said some video just uploaded, but I don't remember uploading a video. 94. Defendant Doherty and John Doe officers 1 to 5 had a constitutional duty to intervene to prevent the violation of plaintiffs' constitutional rights when they had the opportunity to do so. These defendants observed the constitutional violations occurring in their presence, including the execution of a fraudulently obtained warrant and excessive force used against the plaintiff. I know, right? Yeah, this is the result of 8 years of fuckery. I mean, like literally when they've when the same people have done the same things and it's been one attack after another and it's been cover one thing up with another thing. When I literally when they had attorneys in the area swayed because of the influence. When, you know, they kept continuing to make me broker and broker. When I kept losing opportunities, when I couldn't get, hired onto opportunities because of the label that they had unfairly attached to me. Well, I had to learn how to do it myself because it's either sink or swim. I mean, it's either, I get completely eaten alive because I can't find legal representation, or I take advantage of my time and I learn the law. And that's what I did. I took advantage of my time and I learned the law, especially whenever I was when I was incarcerated. I stayed in that law library. I stayed in the law books. Yeah. 96. The defendants had sufficient time and opportunity to intervene uh, to prevent the violations, but failed to take any action to protect plaintiffs' constitutional rights. That's why we need to record the absolutely always record. The failure to intervene was objectively unreasonable under the circumstances and violated clearly established law requiring officers to prevent constitutional violations when they had the opportunity to do so. Um, Count five. We're almost there. Okay. Um, let's see. I lost my live stream. Where is it at? There it is. Clicked off. Okay. Count five. Conspiracy to deprive civil rights. They better be glad I haven't added civil RICO onto here yet. All right, because I have half a mind. I have half a mind to add civil RICO on here. I don't. That's one thing I can tell you right now. They don't want civil RICO. Uh, so paragraph 2 and paragraph 3 in 1985. 98. Plaintiff incorporates by reference all preceding allegations as if fully set forth herein. 99. Defendants conspired among themselves and with others to deprive the plaintiff of his constitutional rights under color of state law in violation of 42 U.S. Code 1985, paragraphs 2 and 3. And, what I want to do, as soon as I get to the end of this, okay, for those that are still on here that want to check it out with me, we'll look at 42 U.S. Code 1985 because it's a very interesting statute. Okay, 1983 is a civil rights statute, but yeah, RICO is 100% what this is because it's an enterprise. Okay, anytime you have an enterprise, which is more than one person, and they're committing acts of conspiracy uh, that can be charged under the civil RICO statute. Okay, and honestly, it needs to be charged under the criminal RICO statute. Okay. 100. The conspiracy involved A. Coordination between Texas and Mississippi law enforcement officials. B. Sharing of false information to support fabricated charges. C. Procurement of search warrants through perjury. D. Suppression of exculpatory evidence. E. Provision of false official correspondence. And F. Continued prosecution despite knowledge of the charge's falsity. And honestly, that paragraph right there spells out RICO, civil RICO. I mean, I probably should add that on there. I should probably cut my teeth with a civil RICO right here. 101. Defendants acted pursuant to an agreement or meeting of the minds to deprive plaintiff of his constitutional rights as evidenced by their coordinated conduct across state lines and their mutual assistance in maintaining false charges. 102. The conspiracy was motivated by retaliatory animus against plaintiff based on his previous legal challenges to Mississippi authorities and discriminatory animus based on his exercise of First Amendment rights as a government accountability advocate. Um, Now they should get the capital punishment for what they've done, because they're not going to stop. It's never going to stop. It's treason is what they've committed the crime of treason. 103. Defendants committed overt acts in furtherance of the conspiracy, including but not limited to the false arrest and prosecution, the interstate communications sharing false information, the procurement of fraudulent search warrants, the forced blood draw, the provision of false official correspondence, and the maintenance of prosecution despite exculpatory evidence. I want to, I want to ask y'all, those that know what's gone on over here in Utah, okay, with Captain Hilden Sessoms and Layton PD, okay? I mean, do you see a pattern here? Do you see what's called a pattern in practice? All right. This is why I say they're never going to stop, ever. They've proven it. But, okay, well, not that, okay, yet, but the interstate communications sharing false information. Sound familiar? The procurement of fraudulent search warrants. I mean, hey, illegal interstate surveillance, finding out my address within a matter of hours or a couple of days. Nobody had the address. All right. The provision of false official correspondence. Well, what did he send via email? As a result of the conspiracy, plaintiff suffered the injuries alleged herein, including deprivation of liberty, emotional distress, and reputational harm. Count 6, municipal liability. I'm going to speed it up a little bit. Deliberate indifference. Monell claim against defendant city of Galveston. Okay. 105. The plaintiff incorporates, yada yada. 106. The city of Galveston is liable under Monell versus Department of Social Services for the constitutional violations committed by its employees as these violations resulted. So, in order to actually sue a municipality or to sue a county, a municipality, we'll say, all right, you've got to get around uh, the Monell claim, and it's basically you have to show that they knew about something and they didn't correct it. They um, they knew or they should have known, and they did nothing to correct it. And that's where you truly get vested with the standing to sue a municipality. 107, the city of Galveston maintained policies, customs, or practices that were the moving force behind the constitutional violations, including inadequate training regarding constitutional requirements for warrant applications and DWI investigations. B. Failure to implement proper supervisory oversight to prevent perjury in warrant affidavits. C. Failure to discipline officers for constitutional violations and perjurious conduct. D. Customs permitting discriminatory targeting of First Amendment auditors. And E. Deliberate indifference to patterns of misconduct by officers like Osteen. I mean, if I don't win on something where they dismissed both charges and it's crystal clear on the evidence like this, then we have no. I mean, there's no faith left in our legal system. We have no legal system that can be trusted at this point. That's I'll put it that way. I certainly won't have any respect for the court, or honestly the system of law at that point. If that's actually the case, that's just this that's absolutely ludicrous. They have to they have to be held accountable for this, and the court needs to do it. And it also, it comes back to one of the important things here is what we're supposed to have, but we don't have the separation of powers. Okay. The legislative, the executive, and the judicial branches are all supposed to work independent of each other. It's basically a to make sure that this all doesn't, that tyranny doesn't completely take hold. Um it's a check on power. But as I said, I honestly I feel like that those lines have gotten completely blurred, and I really don't feel like we have much of a separation of power in our government anymore. It's gotten out of hand. 108, the city's policies and customs demonstrated deliberate indifference to the constitutional rights of individuals subjected to DWI investigations and arrests, particularly those engaged in First Amendment protected activity. 109, the constitutional violations alleged herein were not isolated incidents, but reflected systemic deficiencies in the city's training, supervision, and oversight of its officers, constituting a pattern of deliberate indifference that was the moving force behind plaintiffs' injuries. 110, as a direct result of the city's policies and customs, plaintiffs suffered the constitutional violations and resulting injuries alleged herein. Count 7, institutional liability against the hospital. Plaintiff incorporates by reference all preceding allegations fully set forth herein. UTMB Health is a state actor is liable for the constitutional violations committed by its employees and agents who participated in the forced blood draw procedure. 113. UTMB Health maintained policies or customs that permitted its medical personnel to perform invasive medical procedures on non consenting individuals without independently verifying the validity of law enforcement warrants or the voluntariness of consent. UTMB Health's policies demonstrated deliberate indifference to the constitutional rights of individuals subjected to forced medical procedures in conjunction with law enforcement. As a direct result of UTMB's health policies and conduct of its employees, plaintiffs suffered constitutional violations and resulting injuries. I believe this is the last claim right here. Count number 8, state law claims. Texas common law, false imprisonment, assault, battery, and intentional infliction of emotional distress. Plaintiff incorporates by reference, yada yada. 117, false imprisonment. Defendants intentionally confined plaintiff without legal justification, causing him to be detained for approximately 11 months based on charges they knew to be unfound and evidence they knew to be fabricated. 118, assault and battery. Defendants intentionally caused harmful and offensive contact with plaintiff's person through the forced blood draw and physical restraint, or performed pursuant to a warrant obtained through fraud and without proper legal justification. 19, intentional infliction of emotional distress. This is also called the tort of outrage. Okay. There's negligent infliction of emotional distress and there's intentional infliction of emotional distress. And actually, when I modify it and amend the complaint, I'm actually going to add negligent infliction of emotional distress to this as well, because honestly, there's both of them. I mean, I think that if intentional doesn't apply to UTMB, the hospital, I think that negligent does right there. Defendant's conduct was extreme and outrageous, exceeding all bounds of human decency, and was intended to cause or recklessly disregard recklessly disregarded the substantial likelihood of causing severe emotional distress to plaintiff, the deliberate fabrication of evidence, procurement of warrants through perjury, and coordination of an interstate conspiracy against the plaintiff constitutes conduct so outrageous as to exceed all bounds of human decency. As a direct result of the defendant's tortious conduct, plaintiff suffered significant injuries, including emotional distress, physical pain, loss of liberty, and reputational harm. All right, damages as a direct and proximate result of defendant's unconstitutional conduct. Plaintiff has suffered and continues to suffer significant damages, including but not limited to compensatory damages, loss of liberty for approximately 11 months for wrongful incarceration, physical pain and suffering from the forced medical procedures, severe emotional distress, mental anguish, and psychological trauma, damaged reputation and standing in the community, lost income and earning capacity, medical expenses and costs relating to treating psychological trauma, legal fees and costs incurred in defending against false charges. Punitive damages. Defendant's conduct was malicious, wanton, oppressive, and demonstrated reckless disregard for plaintiff's constitutional rights, including deliberate perjury and warrant applications and judicial proceedings, warranting an award of punitive damages to deter similar conduct and punish the wrongdoers. Prayer for relief. Wherefore, plaintiff respectfully requests that this court exercise jurisdiction over this matter and enter judgment in favor of plaintiff and against all defendants. Award compensatory damages in an amount to be determined at trial for the injuries, losses, and damages suffered by the plaintiff. Award punitive damages against all individual defendants in an amount sufficient to deter similar conduct and punish the constitutional violations, including the deliberate procurement of search warrants through perjury. 4. Award reasonable attorney's fees, costs, and expenses pursuant to 42 U.S. Code 1988. 5. Grant declaratory relief declaring that defendant's actions violated plaintiff's constitutional rights under the First, Fourth, and 14th Amendments. 6. Grant appropriate injunctive relief to prevent similar constitutional violations in the future, including requirements for additional training on constitutional requirements for warrant applications and the rights of First Amendment auditors. 7. Grant leave to amend this complaint as justice requires. 8. Award pre- and post-judgment interest as allowed by law. 9. Grant such other and further relief as this court deems just and proper. I'm sending all these defendants into bankruptcy is my goal. Jury trial demand. Plaintiff hereby demands a trial by jury on all issues so triable as a matter of right. And that is it. So, as I said, I've got to amend that complaint, and I want to let's see. I'm going to do this real quickly. Let's see, new window. WTP. Hang on a second, folks. Hang with me a second. Let's see. Change this right here to Phantom. Okay. What you see here, and like I said, I've got to update it. I've got to put new I've got to put new content, new articles up. I wanted to come here first of all because I had a let's see. Where is it? So I've got I had a different song. I have a feeling that Hobie James might be on here. And and I've got a song for him. Under my draft. There it is. Yep, I had it on draft. So publish, publish. All right. All right, cool. Let me refresh. Mhm. What the hell? Post, published, new song, false witness, settings. Not that one. Stick it to the front page. All right, refresh. There it is. Okay. And I don't think I have the audio turned on this. Let's see. Yeah, it's on. Sorry about that. What the hell? Okay. So I don't know what's going on right there. That's obviously not supposed to happen. Uh, let's see, audio capture, system audio capture. I don't know. All right. Let me try this real quickly, and I'll come right back to that.
For the ones who got, yeah,
Yeah.
this one right here is for the people. For the ones who got set up, lied on, framed. For the ones who fought back and got punished for it. Candace Beavers, Hobie James Osteen, this one's for y'all. They put their hands on the Bible, swear to tell the truth, but Beavers took the stand just to fabricate the proof. She said I had no reason, no permission to be there, but the calls don't lie, check the records if you dare. I told her I was coming, FBI was in the loop, but she twisted up my words, turned my rights into a noose. Now I'm sitting in that cell while she's smirking in the court, a badge and a gun, but the truth she still distorts. Hobie in the shadows pulling strings like a ghost, so seen on the beat, trying to send me up the coast. They ain't like the way I spoke, put their names in the light, so they linked up with Galveston. Tried to bury me in spite. False witness, perjury, they lied on me. Tried to take my freedom, but I'm still gon' speak. Retaliation, I see what y'all be. Beavers, James Osteen, corrupt police. August 2023, I dropped a vid, let it fly. Exposed what they was doing, had them nervous on the slide. Next thing I know, they plotting, trying to take me back. Using Galveston's finest for their cowardly attack. Tell me how that work, y'all supposed to serve and protect, but instead, y'all protecting your rep with disrespect. Y'all ain't law, y'all just gangsters in a government fit. If the truth's a crime, I guess I'm guilty as it gets. Said I broke probation, but the facts ain't a line. Phone calls don't vanish, check the date, check the time. Y'all fabricated charges like a script from a play, but karma got receipts and she running up the pay. False witness, perjury, they lied on me. Try to take my freedom, but I'm still gon' speak. Retaliation, I see what y'all be. Beavers, James Osteen, corrupt police. How you cover your self-law when you break it with ease? Sworn to protect, but you're moving like thieves. Weaponize the system just to silence a man, but the truth don't die, better watch where you stand. You'll try to lock me down, but my voice still free. Every line that I drop, it's a charge on me, not in the courtroom, but against your frauds, lying under oath just to play like gods. I see the setup, I peep the scheme. Judges play along, it's a whole machine. But the truth got power and the people gon' see how y'all try to take my life just for speaking on thee. False witness, perjury, they lied on me. Try to take my freedom, but I'm still gon' speak. Retaliation, I see what y'all be. Beavis, James Osteen, corrupt police.
Y'all got me? All right. Yeah. All right. So I want to go over a couple of things here on this site because I've said this time and time again how important this website is. I've got a few websites actually. Um, and I've actually got another one that's about to go up. Don't really want to talk about that one yet, though. WTPnews.org. All right. It's so we can come down here to, I think the first article I have on here is talking about um, it's that massive federal lawsuit that I filed against Fayette County for the commitment scandal. Um, I've got the article on there for when I overturned the Batesville ordinance, which is pretty cool. But then we get into this right here. Okay, the third. If you want to know, like, really what's going on, you know, look at the truth. Look at the evidence right here. You got the attack on the press, journalist trapped, railroaded into prison in Mississippi. That's about going into City Hall as a journalist, and it leads to the aggravated stalking charge they put on me. Staged DWI arrest of journalists. So I put this article out on March 3rd, 2025. Um, this is, well, you know, I just read the complaint. Most of y'all should know what happened with the Osteen thing, but let's have a reminder.
Okay, where are you headed to, man?
Right here.
Right here?
Yeah.
Okay.
Meeting up some friends.
Okay.
They're literally the ones taping you right now.
Okay.
I'm live on YouTube.
All right, Mr. Matthew, I'm gonna ask you a question. I need you to be honest with me, okay?
Yeah.
All right, have you been drinking tonight, man?
Not a single thing.
Okay, then how come I smell alcohol coming from the car?
I hadn't had a drink, dropped a drink for 3 years.
Well, that's what I'm saying. He didn't do anything wrong either.
He's got to go to the county jail to blow in the breathalyzer.
Suspicion is not a crime, though, man.
He wants to go blow in the breathalyzer.
Why
As
did
you
you
know,
put him in
that
handcuffs?
because he put his hands on Jack and put me in
That's what I'm saying. I'm
Okay.
putting my hands behind my back right now saying, put me in handcuffs. Why would you do it to me? No different.
What's going on, ladies and gentlemen? You're watching the footage of Lafayette County audits driving into Galveston city limits. First time in Texas. This man's been driving all day. He left Mississippi, drove through Louisiana, and drove halfway through Texas to meet Good Citizen News and News Now Ninja. And as soon as he crossed the Galveston city line, he got pulled over and got arrested for a felony third offense DUI with no evidence of a DUI or probable cause. But we're going to get into that. But first of all, I just want to say that he stopped in Houston before he made it to Galveston and visited with News Now Ninja. They did a live stream and he announced his plans to come to Galveston within the hour or two. And that was a bad idea. Then when he got in his car and left News Now Ninjas, he went live again telling everybody he's on his way to Galveston. Well, apparently a troll called the Galveston Police Department and told the police of his plans to come into Galveston and told them that he was live streaming. They watched him on his live stream come right across the bridge into their town, and the rest is history. Let's get to the video. I'll see y'all later.
All right, we are. Oh, well, we're already getting pulled over. Already getting pulled over. Yes, sir.
Officer Murph, GPD, you got your driver's license, man?
Yeah, can I ask what you pulled me over for?
Yeah, sure, several things. Fail to maintain a single lane, turn signal.
I'm new. This is the first time being over here, so I was trying to find it. Trying to find my friends.
All right, you got your driver's license?
I actually don't, but I can give you my number.
Okay. Do you have any form of ID on you?
I don't. No.
Never roll your window down any more than just a little crack, for 2 reasons. You don't want them reaching in and grabbing you, and you don't want them lying like these cops are going to lie and say that they smelled your breath and smelled alcohol on your breath, which is exactly what's going to happen. You can say everything you need to say through that little crack, and you can present your ID and your driver's license and your insurance paperwork up against the glass. The law says you have to present it, not hand it to them.
What's your number?
It is 801. Wait, so before I give you this, you said that I was failing to maintain a lane. I've actually got the cam right here that shows that I was driving straight. I was literally.
That's fine. I've got my camera too.
Okay.
You're gonna give me your number? What state is that out of?
Mississippi.
Mississippi. What's your last name?
Reardon.
It's what?
Reardon.
Reardon. Can you spell that for me, please?
Reardon.
R-E-A-D.
Reardon.
And your first name, sir?
Matthew.
Birthday? All right, Mr. Matthew. Anything in the Duke going to be aware of? Guns,
No.
knives, or anything like that?
Nothing at all.
Okay. Hang tight for a minute, okay?
All right.
Hey, what's going on, man?
Hey, can I get your name and badge number, please?
Yeah, Officer Osteen 692.
Okay. You doing all right tonight?
Yeah, how are you?
I'm all right.
How are you tonight?
Oh, just touring Galveston. First time being to Texas.
First time being in Texas.
Yeah, hadn't been through Texas. I do a lot of traveling around the country, but this is the first time actually coming through Texas. Wanted to see Galveston.
You auditor, man?
I don't answer questions.
Okay.
You heard that? Officer Osteen asked him if he was an auditor. Why is that important, and where did he come up with that from? Anyways, my man answered that question the right way. He says, I don't answer questions. I wish that would have been his answer for every question for the rest of the night.
What's up, guys? He said, I don't know, he said basically failure to maintain the lane. But I mean, I've got dash cam right here. I was trying to look out to see where the gas station was, and
Hey, man, you said it's your first time here?
yeah.
Hey, what's your name?
It's Matthew. I mean, y'all look up.
Okay. You have his license on you?
It's Matthew.
Matthew what?
Reardon.
Matthew what?
Reardon.
Reardon?
Yeah.
Okay, what's your date of birth, man?
March. The guy not write it down?
Okay, where you headed to, man?
Right here.
Right here?
Yeah.
Okay.
Meet up some friends.
Okay.
They're literally the ones taping you right now.
Okay.
What happened to I don't answer questions? And don't ever, ever tell the police that you're coming to meet with the cop watchers that are filming you guys right now. the ones that film them all the time, and the ones that they literally cannot stand.
I'm live on YouTube.
All right, Mr. Matthew, I'm gonna ask you a question. I need you to be honest with me, okay?
Yeah.
All right, have you been drinking tonight, man?
Not a single thing.
Okay, then why come I smell alcohol coming from the car?
I hadn't had a drink, dropped a drink for 3 years.
Nothing for 3 years.
3 years.
3 years, okay?
You smell me?
I can smell you.
This is why you never roll your window down, but just a little crack, because these cops can say they smell things, and there's no way to prove that a cop is lying over his smell in court.
No alcohol.
No alcohol.
None.
Okay. You still have the vehicle, Mr. Matthew?
Sure. I just pulled the mask down in blue. You don't have a single...
Okay. Matthew, walk back here with me, man?
Yeah.
So you're telling me, Mr. Matthew, you haven't had a drink in 3 years?
3 years.
Okay.
On my kids.
Huh?
On my kids.
On your
3
kids?
years.
All right, Mr. Matthew, you mind doing some tests? Make sure you're okay to drive, man?
I mean, do you smell alcohol in my breath? I hadn't had a single thing to drink.
That's not answering my question.
I'm not taking... Your field sobriety tests are designed to fail. You know it and I know
They're
it.
not designed to fail. The first one's scientific.
How about this? Let me blow.
Huh?
I'll blow.
You want to blow?
I'll blow.
Okay, you understand.
Yes, I understand. I haven't had a drop to drink.
Let me explain something to you.
I haven't had a drop to
Let me
drink.
explain something to you, okay?
I have not had a drop to drink.
Okay, I'm understanding that.
Okay.
I understand you're saying that, okay? What I'm telling you is, you understand that if you blow, I have to place you under arrest.
Yes.
Okay.
This is why you don't ever answer questions, because these cops are going to play word games and twist his words and try to confuse him, just like he just did. He said, you understand, if you blow, I have to take you into jail. Now, Lafayette County thought that he meant if he blows and fails, he has to take him in. But they're going to continue to play these word games and twist his words up. You guys just watch and just remember, this is why you never talk to the cops and don't ever answer questions.
100%.
Okay.
Yeah. Go get it.
That's not how it works. We don't go get it. We go to the machine.
Okay. No, sir. No, sir.
That's where the machine's at.
No. Call supervisor.
The supervisor's right there.
We're not doing this. No. I'm taking it right here. No, I won't even take it.
Mr. Matthew.
Yeah, I refuse
Are
it.
you willing? You're refusing? You're refusing?
I want a lawyer.
Yeah, I don't need to give you a lawyer. Are you refusing the field sobriety test?
I said I will blow.
Okay. We have to go to
Bring
the
it
jail.
here. Y'all have portable tests. Y'all have portable tests.
We don't.
No, we do not.
We don't.
We don't have them.
I don't know what to tell you. We
The only
don't.
one we have is at the police station. It's the only one we have.
You got a supervisor?
I am a supervisor. Right here.
What's your name and badge number?
Sergeant Jack Doherty, 344.
344. And you are...
I've already told you.
I know. What is it again?
Officer Osteen 692.
Osteen. You are?
Murph 617.
Okay.
Okay. I'm going to ask you one more time, Mr. Matthew. Will you consent to field sobriety test?
No, not... I said I'll blow. Otherwise, take me into custody.
Okay.
Suspicion of DWI.
Hey, can you get my gimbal?
Crying, man. He does not want to do the field sobriety test. The sobriety test is voluntary. He requests to blow in the
I said I would blow. When I blow, zero.
To search that car?
Just towing it. That's why. Once they take him into custody.
How can they take him into custody? There's no crime. Suspicion is
If he
not
blows,
a crime.
if he blows zeros at the jail, are y'all gonna let him go,
Suspicion is not a crime.
Sergeant Doherty, or is it Lieutenant?
You need to let him go, man.
Is it Lieutenant or Sergeant? It's Sergeant. If he blows zeros at the jail, are y'all gonna let him go, or? Okay.
What we're doing right now is exactly what he wanted to do.
Well, I know. I was
This
just
is what
curious.
he wants to do.
Oh, I know. I was just curious.
All he had to do was take the test.
I know. I'm just curious
He
as
didn't
to.
know. He requested to take a breath test. The breath machine is at the county jail. We
Yeah,
don't have
I
portable
understand
machines.
that. I understand that. He doesn't understand y'all don't have them. Yeah. No, but so if he goes to the county jail and he blows zeros, like then y'all have nothing to hold him on, right?
I don't know what the initial stop was. I haven't got that far yet.
Okay.
Okay.
Well, I think he said it was something like failure to maintain lane or something like that.
I don't know.
Okay.
I got to review body camera. You know.
Yeah, no, I get it. I get it.
Okay, so he said he wanted the blow.
Yes.
Well, why is he in handcuffs?
Because they're
then?
taking him to jail because
So
that's where
what?
the breathalyzer's
He
at.
hasn't been charged with a crime yet.
Our
Why?
policy states if you're going to ride in the back of that car, you're going to have
That's an
handcuffs on.
unlawful detention, though, man.
He's requesting to go.
He didn't request to get
Yes, he
handcuffed.
did. It's right here on my camera.
He
He turned
requested
around
to-
and put his hands behind his back.
That's because y'all told him to.
No, we did not. It's
No,
on my camera.
he did. He put him behind his back.
He's
Yeah,
on.
but still, man. I mean, if he's not,
We're doing exactly what he's asking.
But you guys are the law enforcement officers, not him. If he asked to blow, you still don't have a crime.
Do you understand?
Yeah, I understand what you're
Okay,
saying.
look, if I asked you to go sleep with my mother, that doesn't mean you have to go sleep with my mother, Doherty. No, it's not. If I ask you to arrest him because he's ugly, are you going to arrest him because he's ugly? No, it's not. It's the same damn thing. You're the law enforcement officer. You're acting like he's your boss.
I'm doing my job.
No, because he said.
Doing my job.
Oh, okay. So if I say put me in handcuffs right now, are you going to put me in handcuffs too? Go ahead, put me in handcuffs. No, I'm asking you to. Well, that's what I'm saying. He didn't do anything wrong either.
He's got to go to the county jail to blow in the breathalyzer.
Suspicion is
Got
not
to.
a crime, though, man.
He wants to go blow in the breathalyzer.
Why'd
Does
you
he
put
not
him in
have one of
handcuffs?
those? Because he put his hands on back and put me in
That's what I'm saying. I'm
Okay.
putting my hands behind my back right now saying, put me in handcuffs. Why won't you do it to me? No different.
Who's all in here?
There's no crime yet. So they've got him in the back of this car handcuffed. There's no crime.
He's talking way too much, man. He said they want to draw blood on him, is what they just said. All right, they're taking him. He should have kept his mouth shut. He should have asked for his lawyer, and he shouldn't have answered any questions. He should have said, write me a ticket or take me to jail or let me go. And he'd be out of here by now. Are going to look like idiots, man, when he comes back sober. That's why they're drawing blood. They're hoping just to find anything at this point. First it was they smell alcohol. Now they're drawing blood just to find anything. Yeah, they don't have probable cause for this shit. None. They have no probable cause for this. That's why I lost my mind. He volunteered to do this shit. So they charged Lafayette County audits with a third offense felony DUI. They had no probable cause or evidence other than him swerving allegedly, and the man was live streaming when he was driving and lost. So that was a perfectly good reason for him to be swerving. They didn't get a breath test, they didn't get a field sobriety test, and the blood results have not came back yet.
Okay. Um, so yeah, that takes me on a trip down memory lane right there for sure. Um, but yeah, I've got a good article written right here about this. Um, actually, I've already got a press release already um, drafted up for this lawsuit that was filed. Okay, so I told y'all earlier about the motion for a Franks hearing. Okay, if you go to this article, and the direct link to this article is wtpnews.org/Galveston dash conspiracy. And that will take you directly to this article. or you can just go to the homepage of WTPnews.org and just scroll down to this article. Okay. On the article, it's got the defendant's motion for a Franks hearing. Okay. You can click on that and it will pull the Franks, the motion up. And this is what's interesting. This is the facts in here. Okay. A search warrant cannot issue unless it is based on probable cause as determined from the four corners of the affidavit. The affidavit contains these observations or statements, which, when taken together, might justify probable cause for a search. Officer Murph advised defiant that he observed the Equinox fail to maintain a single marked lane multiple times. Officer Murph advised defiant that he observed the Equinox fail to signal when conducting a lane change. Defiant smelled an odor of an unknown alcoholic beverage emitting from the vehicle. Defiant observed Matthew to have watery, glossy eyes, walking heavy-footed, speech slurred and thick-tongued, eyes watery and dilated, odor of alcoholic beverage on breath, moderate, refusal evidence. After placing the suspect under arrest for driving while intoxicated, a sample was requested of the suspect's breath and or blood, which the suspect refused to provide a sample in violation of the Texas implied consent law. Let's see. In Franks versus Delaware, the United States Supreme Court held that where a defendant makes a substantial preliminary showing that a false statement was knowingly or intentionally or with reckless disregard for the truth included in a warrant affidavit, and if the allegedly false statement, let me see if I can close this out right here. There's got to be a way. There we go. Okay. Texas Court of Criminal Appeals has adopted the Franks methodology in dealing with probable cause affidavits. In this case, and actually, I'm looking at it on my phone and I see that it's, that my picture is taking up a lot of the screen. There we go. Okay. All right. Specifically, the following evidence contradicts the affidavit. Hey, I can't speak high enough about my attorney, Benjamin Campagna of the it's the TX Attorney Group, the Texas Attorney Group, out of Houston, Texas. It's awesome. An odor of an unknown alcoholic beverage. The toxicology laboratory report revealed no trace of alcohol in defendant's blood. There were no alcoholic beverages or open containers found in the vehicle. Let's see. Galveston has disposed of the vehicle, making it impossible for defendant to exculpate himself, but the evidence is clear that there's no source from which the smell of alcohol could have come. Odor of alcoholic beverage on breath, moderate. The toxicology report revealed no trace of alcohol in defendant's blood. Moderate is the second highest level of odor and would not be present for a defendant with no alcohol in his system. Further, Officer Osteen clarified multiple times on camera that he did not smell the alcohol on defendant's breath, only from his vehicle. And he cites the body cams right here. He would later testify under oath that once defendant stepped out of the vehicle, he could not detect an odor of alcohol emitting from the defendant. Yet he still, all right, this is very important right here. Yet he still marked that there was a moderate smell of alcohol on defendant's breath in the affidavit. An observation Officer Osteen had already demonstrated he knew to be false. All right. So, eyes watery and dilated. Officer Osteen would later testify that defendant's pupils were very small and that he had pinpoint pupils. This is the exact opposite of the dilated pupils described in the affidavit for his blood draw. Officer Osteen either did not get a good look at defendant's eyes and was just making something up in the affidavit, which is a reckless disregard for the truth, or he changed his story and perjured himself once he discovered that the toxicology report revealed no trace of alcohol. I mean, honestly, he changed his story. We know. I mean, that's all but a given. Walking heavy-footed. All video evidence shows the defendant walking and standing normally. Officer Osteen had virtually no opportunity to observe defendants walking prior to arresting him and obtaining the warrant. Body cam footage shows that Officer Osteen wasn't even facing the defendant for the brief period of time that defendant was walking. Also, heavy-footed typically denotes slow, laborious movements, but Osteen would later testify that defendant was extremely jittery. Speech slurred, thick-tongued. In Officer Osteen's body cam footage, defendant speaks articulately and at a reasonable pace. After having less than a minute of conversation with defendant, Officer Osteen later discusses with Officer Larry Murph how they can go ahead and arrest the defendant, stating he can go off of slurred speech and smell, despite no slurred speech having been observed, no evidence of smell as described above. Thick-tongued usually denotes slow, difficult speech, but Osteen would later testify that defendant was talking extremely fast. F. Refused to provide a sample. Defendant clearly offered to take a breathalyzer test prior to being taken into custody and consented to being taken into custody for that purpose. Officer Osteen had no probable cause to arrest defendant at the point he took defendant into custody, having smelled no alcohol, nor observed any symptoms of intoxication as described above. Officer Osteen would later testify that he did not suspect a substance other than alcohol, except that defendant demonstrated a willingness to take a breathalyzer. So he later testified that because I kept asking for a breathalyzer, that was basically evidence that I was intoxicated. However, being willing to take a breathalyzer is not a sign of intoxication to justify a blood warrant. Officer Osteen recorded only his alleged observations regarding alcohol consumption in the affidavit. Let's see. Changing testimony. Between the time of the affidavit and the time of the probation revocation hearing, Officer Osteen changed the symptoms he claimed to have observed from alcohol. Slow, thick tongue, slurred speech, dilated pupils, smell of alcohol on breath, to another substance instead. Fast speech, small pupils, jittery movements. Each observation was made under oath. All right, this is key. Both of them were sworn under oath, but they obviously both aren't true. It's either one or the other, or none. Such a fundamental shift in observations under oath suggests intentional misrepresentation rather than innocent mistake. Officer Osteen made these materially false or misleading statements knowingly, intentionally, or with reckless disregard for the truth in an attempt to set up the defendant. Look at that, set up the defendant. Upon approaching the defendant, Officer Osteen's body cam footage shows one of the very first questions Officer Osteen asked defendant is, "You an auditor, man?" It's 2 minutes and 48 seconds in on his body cam. He then tells another officer, "Hey, I'm doing this one. This is an auditor." And that's at 3 minutes and 4 seconds in. On information and belief, the city of Galveston has a contentious relationship with auditors. As described above, Officer Osteen had already decided to arrest the defendant after less than a minute of interacting with him before having made any significant observations. Confirming his willingness to lie under oath in order to put the defendant away, Officer Osteen committed perjury in the defendant's probation revocation hearing, twice testifying that the toxicology report had found alcohol in the defendant's system, even though it had not. These contradictions and false statements were material to the finding of probable cause. Without these false statements, the remaining content of the affidavit is insufficient to establish probable cause. Now, look, this is a case right here that blew my mind when my attorney threw this in here, okay? Because I want you to think about this for a second. This is very, very important. The state of Texas's highest appellate court, well, it was either the Court of Criminal Appeals or the Supreme Court. I think it was the Court of Criminal Appeals. So, traffic violations without other indicators of intoxication are not probable cause for a blood warrant. Now, look at this case right here. This Illinois, like, I think it's Illinois. I don't know if it's Illinois versus Gates or Farhat versus State. Holding that driving 10 miles per hour under the speed limit is Farhat. Holding that driving 10 miles an hour under the speed limit, weaving from side to side, turning left while using the right turn signal, seeing 2 pill bottles in the vehicle, the defendant's admission to drinking 4 beers, okay, and the defendant's refusal to take a field sobriety test without objective evidence of intoxication did not provide probable cause for a blood warrant. So, with all of that, and with the defendant even admitting to drinking 4 beers, the Texas Court of Criminal Appeals said that without any other evidence of intoxication, that did not provide probable cause for a blood warrant. It's yeah. So this motion that he submitted has got everything. It's like 84 pages. Okay. It has everything. All right. If you want to see that, WTPnews.org. But yeah, there's a lot of great things on this site, and including right here. This bitch right here is Candy Beavers. She's the one that testified in court, intentionally lied to send me to prison the year prior. I got out. I shouldn't have ever gone because of her lies, and I exposed her. And her and Hobie James, Hobie is featured at the beginning of this video, they're on call recordings calling Osteen. And so we've got that. All right, we got WTPnews.org. I want to show you another site. If you go to LafayetteMS.net, this is another one of my websites for Lafayette County Audit. That was May 25th, 2017. I did a demonstration on the square in Oxford, Mississippi. This was 3 weeks after I was unlawfully arrested by the sheriff's deputy for standing on the sidewalk with the state flag. Came back out here to stress test not only the First Amendment, but the Second Amendment as well. And yeah, it's this site has got a ton of stuff on it. And it even has, so for the First Amendment auditors out there, I've got a case law section right here. Click on case law protecting auditors and journalists. We've got what the First Amendment actually protects. We've got what a First Amendment audit is. And then we've got the cheat sheet of applicable case law auditors should familiarize themselves with and recite to police if needed. Okay. This is for a lot of people on here that fall under the Fifth Circuit, which is Texas, Louisiana, Mississippi, the Batusi, Philip Turner. Actually, courtesy of him, we have this established right recognized by the Fifth Circuit, saying that we conclude that First Amendment principles controlling authority and persuasive precedent demonstrate that a First Amendment right to record the police does exist, subject only to reasonable time, place, and manner restrictions. Those are very limited. All right. First Amendment protects the right to gather information about what public officials do on public property, specifically a right to record matters of public interest. Recording police and other government officials in the discharge of their duties is explicitly allowed. Glick versus Cunniff. Freedom of the press includes the right to record video and audio. ACLU versus Alvarez. Prior to detaining anyone, law enforcement must have particularized objective basis for suspecting the particular person of criminal activity. Let's see. Let me come back on here. Make myself a little bit smaller this time. Okay. The use of foul language or flipping an officer off did not constitute probable cause to arrest an individual. Criminalizing all non-consensual audio recording necessarily limits information. Yada yada. Okay. Why in the world is that blotted out? I think it. I don't. I got to fix that. I don't know why that's blurred out right there. Here's how my story starts. Got, a story. I've got the thing right here with Deputy Tim.
I am audio and video recording, Mr. Pruitt.
I don't care. You have a permit to be here.
The First Amendment,
You
actually.
have a permit to be here.
No.
All right, you got to leave.
Why is that?
Because you're going to jail if you don't.
I'm going to jail just
Yep.
for standing out here and
That's
holding
right.
the flag.
You're demonstrating. Yeah, you have to leave.
Okay, where does that super?
I'm gonna
let me
ask you
just.
one more time.
Can I just ask
I'm
you?
gonna
Can I ask you
no,
a question?
Sir. I'm going to ask you one more time to leave. If not, I'm going to kill you to jail for disorderly conduct.
Okay, I'll leave and take this straight to my attorney then. That's you can't threaten me with my First Amendment rights. Hey, I'm gonna tell you right now, Mr.
Count
Pruitt.
3 to leave. 1.
This fucking city is ass fucking backwards. Ass fucking backwards. Y'all see that? Hey, what's your badge number, by the way, Deputy Pruitt? No, I'm not. I'm leaving. I was asking you. I was asking you. I was leaving. I was leaving.
Show you all that.
That's you can't threaten me with my First Amendment rights.
I got several that I need to get back up and going, but the Communicator Lafayette County commitment scandal. That's the lawsuit I filed right there. all the evidence to literally back up everything that I said or that I claimed. But yet they gaslighted me. Speaking of gaslight, the gaslight anthem is a great one. Let's see. Videos. Downloads. Yep.
Mark Arrington. Your name
Don
is
Matthews.
Don Matthews?
Yeah.
They said it didn't happen, even when the footage showed it. They said you misunderstood, even when you quoted them word for word, for word. They said you were unstable, even when the system was falling apart. This isn't confusion, it's strategy. Gaslighting, the government's favorite tool. But every time they lie, another camera rolls. Every time they deny, another file uploads. Truth is the new rebellion, and we're filming it in real time. This is the gaslight anthem. Is the gaslight anthem. They said it didn't happen, even when the footage showed it. They said you misunderstood, even when you quoted them word for word, word for word, for word. They said you were unstable, even when the system was falling apart. This isn't confusion, it's strategy. Gaslighting, the government's favorite tool. But every time they lie, another camera rolls. Every time they deny, another file uploads. Truth is the new rebellion, and we're filming it in real time. This is the gaslight anthem. Is the gaslight anthem. Is the gaslight anthem. Is the gaslight anthem. Gaslighting, the government's favorite tool. But every time they lie, another camera rolls. Every time they deny, another file uploads. Truth is the new rebellion, and we're filming it in real time. This is the gaslight anthem. Is the gaslight anthem. This is the gaslight anthem. Is the gaslight anthem.
Mark Arrington. Your name
Don
is
Matthews.
Don Matthews?
Yeah.
They said it didn't happen, even when the footage showed it. They said you misunderstood, even when you quoted them word for word, for word. They said you were unstable.
Next will be Matthew Reardon, followed by Ricardo Mejias, and then Ian McCubbin. Matthew, you may now unmute.
Good evening, ladies and gentlemen of the council. My name is Matthew Reardon. I am a journalist, a constitutional rights advocate. I'm here today to sound the alarm on a dangerous precedent unfolding right here in Salt Lake City. Starts at 660 South 200 East, in a building where both the Mexican consulate and the Department of Homeland Security lease space to serve the public. A little over a week ago, I entered that building peacefully, camera in hand, to document a matter of public concern. I was calm, I was silent, I was doing my job. A short time later, I was confronted by an unhinged private security guard, put on speakerphone with a building manager who threatened me with jail and then trespassed by Salt Lake City police officers after being forced to show ID under threat of arrest. This happened inside a building with federal signage clearly citing the rules and regulations governing conduct on federal property. I did nothing illegal, no disruption, no disorder, just journalism. And yet I was targeted. Not for what I did, but for who I am and what I represent. Accountability. That is a viewpoint discrimination. That is retaliatory policing. And that is unconstitutional. The city of Salt Lake cannot look the other way when its officers enforce private whims against protected rights, especially on federal ground. It cannot continue deputizing private building managers to silence journalists and intimidate dissent. I'm here today not just to inform you, but to warn you. A federal lawsuit is being filed, and this time there will be no backdoor deals, no quiet settlements, and no forgetting. This city will answer for what it allowed, and every person in this room will have to decide, do you stand with the Constitution or against it? My camera captured it all. The lawsuit will expose it all, and the people, your people, deserve to know the truth.
All right. Well, I'm going to hand this over to you. I'm following.
Did you give that to Officer Quick?
I'm giving it to you because you're the one that said under threat of arrest. Whenever I give it to you, the lawsuit will be filed.
Can you please hand me the ID?
There you go.
Awesome. Thank you. All right. So
Y'all heard it.
Step the wrong way again.
Another lawsuit.
We'll have business going on again. So we're providing you with notification right now that they don't want you back on property here.
Cool. I gave you notification of what was going to happen because of that. So.
Okay. So just so you know, police report will be generated. Happy to give you that case number if you wish. Sounds like you got everything you need.
Good afternoon. My name is Matthew Reardon. I'm a journalist, a father of four, and a relentless advocate for our constitutional rights. I stand here today at the federal courthouse in Salt Lake City, not just on my own behalf, but on behalf of every American who has ever placed faith in the integrity of our legal system, only to have that faith betrayed. On January 21st of this year, an illegal prison sentence was finally vacated. A sentence that had stolen precious time from my life and my children. Within a week, I relocated from Mississippi to Layton, Utah, looking to rebuild. But almost immediately, illegal surveillance was conducted by Oxford Police Department. And on that very same day, my private address, which had never been made public, was doxed out and disseminated to 139 police officers, along with false and defamatory information. I filed a federal lawsuit on March 31st of this year to challenge this and other constitutional violations. That very day, I went to the FBI here in Salt Lake City to submit a sworn declaration, a formal statement under penalty of perjury. Instead of taking it, I was told a background check was required before I could even speak with an agent. I was reporting the situation standing outside in the visitor parking lot when I was threatened with arrest for trespassing, and my license plate was documented. Since then, I filed 2 separate motions to lift the stay on my case, a motion for recusal, because every day that this stay remains in place, the harm I suffer intensifies. But the court has not acted. The stay remains. The silence continues. And it's not just the court. The Office of the Inspector General has refused to acknowledge either of the 2 formal complaints I submitted, each one backed by evidence and urgency. Not even a case number. The FBI has ignored both of my FOIA requests, filed nearly a month ago. No acknowledgement, no tracking number, nothing. It's like I'm being swatted away by the Department of Justice, treated like an inconvenience, like a problem to be buried. And now, even the federal courthouse behind me, once hailed as the guardian of rights, seems to be joining in. What happened to the separation of powers? What happened to checks and balances? On May 2nd, I was threatened with criminal charges in Morgan County, Utah, for using my alias name, Don Matthews, on public record request submitted under Utah's grammar law. Why? Because my real name had already been doxed. Because 2 reckless municipalities, Layton and Oxford, abused their power and weaponized my identity. So what would any journalist do? I protected myself. And for that, they're threatening me with prosecution. How many more hits am I expected to take? How many more shocking acts of complicity and retaliation must be endured before someone says enough? And what happens if or when the federal court behind me continues to do nothing? At what point does justice delayed become justice denied? Because right now, from where I stand, this courthouse, this symbol of liberty, is beginning to look less like a temple of justice and more like a kangaroo court. I'm calling on the press. I'm calling on the public. I'm calling on every honest official and citizen who still believes in the rule of law. Look at what's happening here. Don't turn away. Demand answers. Demand accountability. Because if this can happen to me, a journalist, a Marine Corps veteran, it could happen to anyone. Thank you for being here. I will not be silenced. I will not back down. And I will not stop fighting until justice is not just a slogan, but a reality for myself and for every American who still believes in the promise of our Constitution. This is Matthew Reardon, reporting live from the Federal Courthouse in downtown Salt Lake City, Utah. We the People News. Okay, welcome. Counties that get away with the same things that they know are wrong, but they're not challenged. So I put together here more of the recent things that have happened right here with Morgan, up to the current. On Tuesday, I have a mediation session with the ombudsman of the state of Utah, and as well as the county attorney for Morgan County. So here we go.
And I want to let you know.
I was gonna. Hey, no. I wanted to actually handle all this myself.
No, and I think that's fine. So now I'm just trying to be transparent with you that my position would be you haven't exhausted your administrative remedies.
Of course.
Now,
I would totally expect you to 12B6.
The way it works in Utah, that you exhaust your administrative remedies and then you can petition the court at that point. If you're challenging the grandma statute itself, then that's another story, right? And you can petition the court directly. So I don't know if that's what you're doing. It could be something.
It's going that direction because I told you the last time.
Yeah.
I was going to, if I got stonewalled here, I was going to use that as my standing to constitutionally challenge parts of the grandma statute under the First Amendment.
And I will not prevent you from doing that.
Right.
I think you're totally within your rights to do that. I'm just letting you know on the grandma side, the statute has a process and you exhaust those administrative remedies and then you can go to court. And I'm just trying to save us both time, right? If we can figure something out.
Well, the thing is, honestly, I I've got a pauper's oath in there. It's not going to cost me anything. I mean, yeah, it might cost a little bit of drive, but that's why I was trying to get this thing worked out with you, you know, without it having to come to this, because personally, man, I think it would be a waste of resources for the county to I mean,
Right.
just you know, turn over the records, man. That's all we need.
Well, and the more that I looked into it too, because I got your email, I forwarded it on. I'm like, hey, now we've got, you know, at least we have the mailing address. And then the other thing too is it does require your name. And then, but I haven't seen your ID, and I have reason to believe that you're actually Matthew Reardon. And I have reason to believe that you're actually Matthew Reardon. And I have reason to believe that you're actually Matthew Reardon. You know?
Who'd you talk to?
I didn't talk to anyone.
He did.
I didn't.
He did.
I didn't. Why do you think I talked to someone about it?
You talked to Mark Arrington, didn't you?
I didn't talk to Mark Arrington. I have no idea who that is.
You did.
I don't.
How did you come to realize?
Well,
All right, how you doing?
yeah, we're doing good. This is Ty. This is Matthew Reardon.
Matthew, good to meet you.
So,
Good to meet you.
How are you doing today?
but no, I have not talked to him, but I think I will now, just so because he may have other information that I don't have.
Now, here's the thing. I'm an author, and I'm a journalist,
Okay.
and it's even got my name on there. Doing business as WTP News, aka Don Matthews. I use the pseudonym, the alias, Don Matthews, and it's because I have been gaslighted. It's because my personal information has been doxed out, and I have every single right. It's not illegal to use an alias, to use a pseudonym.
Well, under the Grandma statute, you have to give your name. And there's penalties up to Class B misdemeanors for obtaining information under false pretenses.
But I've got a sworn document right here that says I am that person and why I use my alias.
And that's fine, but you didn't tell me that, did you?
Well,
And it's
right
not in
here.
your grammar request either. So what I'm saying, there's a process. If you challenge the constitutionality of the statute, I think that's one thing. But as far as, you know, going through the process, we've got to do that first. And so we're not stonewalling you. We're not hiding behind anything. But if you want to submit a grammar request with what's required by the statute, which is your name, mailing address, email address, if you so choose to receive documents that way, and what is it, phone number? Anyway, there's those things that I outlined in the statute.
Why he's sitting here?
Yeah. Well, so you've made some people uncomfortable in the building. You've made some people uncomfortable in the building. And
I've been a journalist. I came in here to file court documents, and that's literally it.
Right, but you gave a false name.
No, that's not the case at all. I can tell you right now, if we're going to go down this road,
we can go down that road.
The name Don Matthews. I have every lawful reason to use a pseudonym, to use an alias, and it's because of
not
what
on a
happened.
government document with a request.
Okay.
And I'm telling you that right now. I've read the statute. I went
All
back
right,
through it.
let me ask you this, okay? Show me a signature on there.
I don't see a signature.
Because there's no signature line. So I didn't sign my name. See, this is retaliation right here. I come in here to file a lawsuit, and
I came here because I said I'm a notary and I can help you. I didn't realize it was a lawsuit.
okay,
but
and then
we
you
can
bring
still...
and then you bring law enforcement over here and you start talking about me using my pseudonym name, my alias name, and you're talking about criminal charges, and this is straight up harassment and
I
intimidation.
didn't bring law enforcement over here. They came. There's been
But we
unease within the building.
had no issues. We were sitting here having a cordial conversation about this
I
lawsuit.
completely agree.
And then this right here is intimidation.
Matthew, let me ask you. So, do you feel that you haven't raised your voice at anyone else in the building?
No. Do you want to look at the videos? In fact, they're on my YouTube channel.
Well, I know.
Show me one thing. I have the right to redress my government.
I agree with that.
And in fact, if I want to say fuck every single person in here, I can say that because that's my right under the First Amendment. But I have not gotten anything out really. The videos are public, okay?
I get
so
it.
you can't say that I've said anything, I've done anything wrong.
Well, except filing a grammar request
You know
that
how-
requires your name.
I do it everywhere because I've gotten doxxed. Okay?
Well, and that's fine for you.
Because
too.
I have the right under the First Amendment to request records with some anonymity because of me being gaslighted.
You don't have a right to do it under anonymity.
Show me where on this paper where anybody can actually know when they fill out a request that they can't use a pseudonym or an alias.
I'm not saying it's on there.
Okay.
But the statute itself
Well,
says it.
you know what? You cannot criminalize something that the public is not made aware of.
Ignorance of the law is not a defense. You know that as well as anyone.
Okay, and
so
a pseudonym.
The
We're
Grandma
both.
statute says what it says.
But we're both at a standstill here because I'm telling you that a pseudonym, an alias, is there's nothing illegal about it, and especially being a journalist, and especially being an author, especially being doxxed, especially being wrapped up in federal civil rights litigation right now against 2 different municipalities that decided they were going to take my information and dox it out. Please tell me how that's justifiable.
And I'm not saying it's justifiable, but we are at a standstill. That's the one thing I
Well,
agree with you, because
okay.
I don't know all the history of the other things. Here.
So they're talking about charges here, and you got law enforcement comes and sits down at the table and puts the body cam right there. Share this out.
Okay, so
now we're going to look at aliases, and you're going to try to actually come over here and intimidate me with law enforcement.
I'm okay if you guys go. Like, I'm not trying to intimidate you.
Take a hike.
Well, I mean, they'll go if they want to go.
Well, then I'll go also. If we're gonna, if that's going to be the case,
you can go too. I'm just saying.
If that's going to be the case, then y'all successfully intimidated me away from here, and that's going to make for a great story.
But Matthew, I'm not intimidating you away.
Well,
I'm just
then
telling.
These people need to take a hike.
They don't need to, but
Yes,
they can
we're
choose
talking-
to,
we're
just
talking
like you
about-
can
we're
choose
talking
to as
about-
well.
We're talking about legal shit that has nothing to do with law enforcement.
What I'm telling
they
you
need to take a hike.
Is what's good for the goose is good for the gander. So if you're free to be here, they're free to be here. I told them I don't need them to be here, and they can go.
I'll let you guys
But
talk.
you can't tell them that you can't order them to leave. It's a public space.
Okay, well, and I
So
can just
just-
as easily get up and walk the fuck out.
And you could, and I'm not going to stop you from doing that either. But I willingly came to chat with you. Is
Okay, and
that
then
true?
And then you brought some law enforcement goons with you.
I didn't bring them with me. They came out, and I appreciate them coming just to check up on me.
Yeah, because I'm such a damn.
Please, it's not a key to jail.
Uncle, what's your badge number, by the way?
Good afternoon, U.S. Attorney's Office.
Yes, it's Blowhard Bob in. Bob Norman.
Okay, may I ask who's calling, please?
It's Matt Reardon, the outlaw.
Okay, hold on, please.
Bob Norman.
Bob Norman.
Is not available to take your call. Please leave a message after the tone. Press the pound key to end recording.
Bob Norman. Matt Reardon. Hey, I wanted to ask you if you knew who the 2 FBI agents that I sat down with back in 2017 were. I know that you had called ahead, and I can't recall their name.
Per the right granted to me in the Constitution, I have every right to seek justice.
And it's very important at this stage of the game, and I would like to find out who they are. Every right.
granted to me under the United States Constitution.
Apparently, the 302 has just grown 2 legs, disappeared. Hey, check out outlaw.news. Outlaw.news.
Justice. Under the United States Constitution, you're a crooked son of a bitch.
And check out writingwiththeoutlaw.com. I think you'd find that pretty interesting. Check out the evidence. Don't, at this point, plausible deniability is off the table. What I am basically demanding at this point, for me to have been guilty of the state's charge would have made it that I was guilty of lying to the FBI. So I'm either demanding to get indicted for lying to the FBI or for Robin Tannehill to be indicted as part of the election fraud that happened back in 2017. Now, I doubt that's going to happen, okay? But there's no way that I could have been guilty of the state's crime and not have been guilty of lying to the FBI. So, one way or the other, the evidence deserves its day in court. It deserves a trial. And that's what I'm asking for. 662-812-1613. 662-812-1613. Thanks, Bob.
Remember this phrase. When freedom is outlawed, only the outlaws will be free. I don't mind being an outlaw at all. I don't mind wearing it on my shirt. It's ridiculously hot outside. It was a coincidence. It was a little bit more probably than a coincidence that my feed was cut out here. Of all places, welcome, welcome, welcome. For those that are on here, I'm Matt Reardon, the Oxford Outlaw. If you do not know me, I've been covering my own political framing back in 2017. And on Friday, I hand-delivered my letter here to the U.S. Attorney's Office in the Northern District of Mississippi, right to the hands of Assistant U.S. Attorney Bob Norman. I did so on those very steps right there. Bob gapped it off. I asked him if he remembered me. I had put my trust in this Assistant U.S. Attorney back in May of 2017 when I had a death threat issued to me, when my right to free speech and in petitioning the government for a redress of grievances was ultimately shot and destroyed by the Tannehills, the incoming mayor of Oxford, Democrat, socialist mayor. I was on the agenda to speak out June 6th, the day of the election, and that was effectively canceled when an emergency injunction was taken out on me, barring me, keeping me 500 yards from the soon-to-be incoming mayor. The soon-to-be incoming mayor. My wife just brought me a snow cone. And on a hot day like today, a snow cone really does help. Okay. So, to fill you in, Friday I hand-delivered my inked letter to Blowhard Assistant U.S. Attorney Bob Norman. And I didn't have that nickname for him before until I figured out that his corrupt ass was part of the problem.
So, what happened? I said, "Do you remember me?" He said, "I do." And he looked at me when he first saw me like he already knew exactly who I was. I knew he knew who I was. I just couldn't remember what his name was. I put my trust in this assistant U.S. attorney to guide me in the right direction, or to take the evidence I already had and do something about it. The problem is, because I'm not a disgusting liberal, because I'm not a socialist, because I'm not a Democrat, because I don't fit the agenda of this city that they're aggressively trying to shove down the throats of the citizens in this area, because I take a stand for what's right, for the Constitution, for Southern heritage. I had information that would have had ramifications on the incoming mayor and her husband back in May of 2017. I told Bob I was trying to find out why the U.S. Attorney's Office for the Northern District, which has a fiduciary responsibility, a moral responsibility to investigate crimes of corruption and certainly to prosecute them if they exist, why over about 2 months' time I got the runaround, I got kicked to the back. They refused to give me a call and look at all the evidence that I had gathered in regards to this being 100% framed, my civil rights being conspired upon to be removed. He wouldn't give me an answer. I had requested, and I have been long now in wait of, the 302 investigative report generated by the FBI from a sit-down meeting that I had with him May 25th, 2017, where I discussed the death threat that was on me, where I discussed how my rights, my civil rights, my First Amendment right to speak, as well as petition the government for a redress of grievances, how that was thrown away due to a cheap shot injunction. And anytime the FBI meets with a citizen, anytime that there's any kind of interview, especially at a field office like it was done, it's supposed to be done in the presence of a second agent. And that was the case. There were 2 agents that sat down with me in the conference room of the local field branch office in Oxford, Mississippi. In a FOIA request, a public records request, I have requested the 302 from that sit-down meeting to corroborate everything that I've said. I also know that the FBI is a politicized weapon. They've been a politicized weapon. They especially were activated as a political weapon when the 45th President of the United States, Donald J. Trump, was elected to office. You see the proof with General Flynn, how the crooked FBI illegally wiretapped him in order to purposefully frame him to try to get inside of the Trump organization. And so I know not to trust the FBI to do the right thing. So in addition to this 302, which is missing according to the FBI, they will not respond to it, I also requested the video evidence of this sit-down meeting to corroborate the accuracy of the 302. And what do you know? the video is deleted after a certain amount of time that they could not specify the amount of time. They simply said that it's up to their technicians to determine. So when I pressed Bob Norman for this, for why they sat by with a moral and fiduciary obligation to answer the call for help, to prevent public corruption, he wouldn't give me an answer. I asked him about why his office would not even so much as return a phone call to examine the evidence. He would not give me an answer. I said, Bob, your office, and this is why I put together the open letter that I did, because whether or not the U.S. Attorney for the Northern District of Mississippi wants to provide answer or not, that letter needs to go on file at the Department of Justice in Washington, addressed to Attorney General William Barr. This corrupt bullshit has gone on long enough. It's affected enough lives, it's destroyed enough lives, and God knows it's destroyed mine. Marine Corps veteran, patriotic citizen. My rights are brutally trampled on, and nobody seems to give a shit. And what is apparently a dumbed down society from people drinking the Kool-Aid that's been given by our government pushing some kind of alternate plan here. And I have full faith and confidence in our Commander-in-Chief, Donald Trump. There are enemies of our country embedded in the alphabet agencies, such as this right here. The FBI, the CIA, the NSA, that are directly causing significant harm to our society. They're not going to stop. They're not going to back down until they completely destroy it. And it's on the citizens themselves to step up and grab the reins and either do something about it or allow it to happen. And if you allow it to happen, you're not going to have your opportunity to save it later. And that's why I'm taking the aggressive approach that I'm taking and trying to vindicate myself through riding with the outlaw, to trying to get to answers. Assistant U.S. Attorney Bob Norman, when I told him that he and his office had a moral and fiduciary obligation to protect American citizens, to go after, to prosecute the real criminals. His answer to me, which was absolutely gawking, was our office is protecting is protecting the public from criminals such as yourself, knowing that everything, the letter, the DVD that I just gave him, everything that I've uncovered and I've published, there's absolutely no way I could have possibly committed the crime that they accused me of. The FBI knew it. That's why the 302 is missing. That's why they will not respond to the FOIA request. That's also why the Sheriff's Department in Lafayette County, as well as Lafayette County's attorney, when pressed for details about that May 24th, 2017 phone call, which through the Sheriff's Office, through their own admission, was what sparked the warrant, what generated the warrant for them to come after me, for them to ambush me on the square in Oxford when I was going to a bar to sit down with a friend to have a beer on May 26th, that was what that came from. And this blowhard U.S. attorney wants to call me a criminal. He's the criminal. He's the problem. He is directly the problem. I wonder how many of these vehicles with dark tint driving by are FBI, the investigative arm of the U.S. Attorney's Office. These people picked a fight with the wrong one. Because honestly, like I said at the beginning, they can try what they want to try. This time around, I don't care. I'm not selling my soul to the devil a second time and pleading out to some bullshit that I didn't do. I'll sit it out like a patriot would, proving my innocence. I'm not allowing this to happen. Because see, here's the thing. I got 4 kids. Well, I got 3 that are biologically mine. All of them are girls. And if I sit back and allow this to happen, if society as a whole has been trained to turn a blind eye to something such as this, if agencies are allowed to conjure up anything that they want to conjure up in order to politically motivate another, in order to remove the liability off of an agency that made a false arrest at the beginning of that month, well then, my daughters, unfortunately, don't have a future or a shot in America anyways. Because America will have long consumed itself before then. So I owe it to them, and I also am doing this to help prevent something like this from happening again. The true criminals need to be held responsible. I couldn't remember if it was May 24th or May 25th that I met with Bob Norman, the assistant U.S. attorney, who then directed me to go and speak with the FBI about the issue. But my wife actually told me that she remembers fairly well that it was May 24th, 2017, that I spoke with Bob Norman. And May 24th, 2017 was coincidentally the day that the mystery phone call came into the Lafayette County Sheriff's Department, investigator Jared Bundard. And after the response that Bob Norman gave me on Friday for simply trying to hold his office accountable, for simply asking why they would not return a single phone call in regards to what was alleged as a horrible public corruption nightmare. A quid pro quo deal that benefited 4 separate parties, including the incoming mayor of Oxford, 2 bar owners, who they themselves were the one that started the little back and forth on Facebook, on social media. It benefited the Sheriff's Department in Lafayette County through the sham arrest that Tim Pruitt made May 1st, arresting me standing in front of the Confederate statue in Oxford on the square, holding the state flag of Mississippi, because I didn't have a permit, and I asked him what his badge number was because he lazily forgot to put it on his uniform. That enraged him, and he made a wrongful arrest. And it also benefited the mother of my now 6-year-old child, who's been used as a chess piece against me in a staged war of the courts, which, by the way, her attorney in the original child custody, the husband of the Oxford mayor. Ray Tannehill, by the way, 3 days ago was appointed by the Mississippi Supreme Court, was appointed to the Mississippi Bar Tribunal. You know, the people that ultimately decide if there was wrongful conduct committed by an attorney. He himself is part of this, he played a huge part. In fact, I don't think that any of this would have gone on if it weren't for Ray Tannehill's involvement. I don't. And how someone like himself gets appointed by the Mississippi Supreme Court to a position that he had absolutely no reason being in light of the serious allegations made, is beyond me. And it just shows how much tougher of an uphill battle this is going to be. That they are, one by one, maneuvering pegs in place to try to once again obtain a favorable outcome at the expense of another. And I myself am one by one putting pegs in place to be victorious in vindicating myself, doing it in the name of justice and patriotism, and to bring the truly responsible parties to justice. In that open letter, go read it if you haven't read it yet. There's a landmark U.S. Supreme Court ruling by the late and great Judge Antonin Scalia. It was United States versus Williams, in which he ruled that the grand jury does not belong to any three branches of government. Rather, the grand jury belongs 100% in its entirety to we the people. And that by that, the citizenry are empowered to impanel a citizen's grand jury to present evidence, to obtain indictments, to try and to mete out punishment to those convicted. And I want this office right here behind me to do their job, to quit kicking the can down the road, to quit passing the buck, to do the job that they're tasked with doing, to produce the evidence requested, to give answer to the questions stated in the letter, although I'm pretty sure that I'm going to be sending it to D.C. without any answers from the U.S. Attorney, and that's just fine. But I think it's very ironic, I find it actually quite humorous, that 30 minutes until 5 o'clock, there isn't a soul at the U.S. Attorney's office in the parking lot. Not only did they not fulfill their duties that they're tasked with, but not a soul up here working at 4:30. And these people are paid for by, guess who? You. Hold your people accountable. We only have one chance to do this. It's nearing bad times in America. Soros is trying to usher this in. Gates is trying to usher this in. Socialists are trying to usher this in. Take a stand for America before it's too late, folks. Matt Reardon, the Oxford Outlaw. Thanks for tuning in. Share this live stream.
U.S. Attorney's Office General Mailbox is not available to take your call. Please leave a message after the tone. Press the pound key to end recording.
Guess I'll leave this message on the general mailbox. Keep getting sent to Bob Norman's voicemail. Bob just doesn't like to return voicemails. This is Matt Reardon. I'm outside of the U.S. Attorney's office here in Oxford. I would like to speak with Bob Norman. I would like to do it the easy way, the non-invasive, non-intrusive way. But outside of that, and deposing, I don't know. There's been some new evidence that surfaced. I need to speak with Bob about this. I need to ask him direct questions. Not trying to cause any problems. Trying to do my due diligence here. I noticed on y'all's website, y'all have a victim witness forum. And different rights for victims and witnesses. Right now, I feel like my rights are being heavily violated in regards to that. Nobody at this office has yet to even speak to me in regards to the evidence. I need somebody to speak to me. Nobody wants to do it willingly. I'll deploy all the reporting gear, and we can just have a news conference out here. But I would like to have a cool, calm, and collected discussion. A news conference out here. But I would like to have a cool, calm, and collected discussion. I'm live on scene at the U.S. Attorney's Office for the Northern District of Mississippi. I need to speak with Bob Norman. Blowhard Bob, Assistant U.S. Attorney Bob Norman.
Well, I'm still trying to get to the bottom of everything. It's been fraudulent concealment. You know you guys are holding on to something they're not giving up.
This is how you petition the government for redress of grievances. So I'm out here because I've been getting the runaround. A lot of bullshit fed to me. Bob has been ducking the buck. His responsibilities as a assistant U.S. attorney. Bob played a pretty big part in what happened in 2017. How big of a part he played, I guess we're going to find out. Okay? But recently, there's been a shocker of evidence. I need Bob to talk to me. Bob doesn't like to talk to me. Me and Bob don't really get along too well. But I want to have a cool, calm, and collected conversation with Bob. Let me turn this camera around, okay? I've got my cameraman right there. That thing follows me around. So I just called up there about 15 minutes ago. I was once again sent to his voicemail. Of course, he didn't answer. And so I called back, and I called back. No answer, no answer, no answer. And they sent me the general voicemail. Left a voicemail in the general voicemail saying that we can do this the easy way or we can do it the hard way. It doesn't matter. Okay? We can do it with the newsreel set, put up in the car, recorders off, just a private conversation. Or we can do it the more difficult way, which involves all my reporting gear coming out, recorders, cameras, the whole 9 yards. Bob needs to talk to me. I doubt seriously Bob's going to catch me on Facebook. And actually, I'm quite surprised. I'm quite surprised that I'm even able to get on Facebook. It's funny that Facebook and Twitter and all that, I've gotten some of the most unfair treatment on social media. For whatever reason, there was a social media platform that, and I don't know if it was YouTube, I don't know if it was.
Hey, those that saw it in the chat, I got to cut this short. I mean, it's been going for a long time, anyways. I'm going to be starting another feed. I got some messages about a lot of cop activity, so we're going cop watching. Yeah.